thank them from the bottom of my heart. I'll start with the land acknowledgement, and typically in their general members meetings, we ask different members to do land acknowledgements. I'm going to do it this time, and what I'm going to do is I'm going to read CUPE Local 5524 works on the traditional territories and lands of the neutral Anishinaabeg and Haudenosaunee peoples. Our employer, the University of Waterloo, is situated on the Haldimand Tract, land that was granted to the Six Nations, which originally included 6 miles on each and interactions within these traditional territories have been and are currently informed by agreements and living treaties based on specific principles and responsibilities regarding land and relationships. We at CUPE 5524 aim to be guided by the principles of peace, friendship, mutual respect, and collectivism represented in these agreements. I'm also going to read the equality statement, which is helpful for setting the tone of how we would like to conduct our meetings and our relationships. And the equality statement is as follows. Union solidarity is based on the principle that union members are equal and deserve mutual respect at all levels. Any behavior that creates conflict prevents us from working together to strengthen our union. As unionists, mutual respect, cooperation, and understanding are our goals. We should neither condone nor tolerate behavior that undermines the dignity or self-esteem of any individual or creates an intimidating, hostile, or offensive environment. Discriminatory speech and conduct which is racist, sexist, transphobic, or homophobic hurts and thereby divides us. So too does discrimination on the basis of ability, age, class, religion, language, and ethnic origin. Sometimes discrimination takes the form of harassment. Harassment means using real or perceived power to abuse, devalue, or humiliate. Harassment should not be treated as a joke. The uneasiness and resentment that it creates are not feelings that help us grow as a union. Discrimination and harassment focus on characteristics that make us different, and they reduce our capacity to work together on shared concerns such as decent wages, safe working conditions, and justice in the workplace, society, and in our union. CUPE's policies and practices must reflect our commitment to equality. Members, staff, and elected officers must be mindful that all persons deserve dignity, equality, and respect. And with that, I'll turn it over to you, Tim.
Thanks, Scott. Yeah, so hi, I am Tim Wilson. I am the national staff rep assigned to 5524. I work with both the Sessional unit and the TA unit. I've been with the local since 2024. I came in early April of 2024. Your bargaining committee put in a ton of work since that time, between sort of reviewing priorities, drafting proposals, redrafting proposals, and then actually getting to the table and dealing with the employer's proposals and negotiating back and forth on that. Your bargaining committee, they gave up tons of their own time. It was all volunteer hours, evenings, weekends. When they should have been doing other stuff, they were meeting with me to figure this stuff out, and Joel and Katie. We do unanimously recommend acceptance of this deal. We think it's a decent, fair first collective agreement. It has a lot of things in it that don't exist or do exist, but they're in more mature collective agreements. So as a first CA, we think this is a good foundation to be working from. So just a couple sort of housekeeping things before I roll into this. It's scheduled for 3 hours. Takes what it takes. If we're done early, great. If it takes longer, we'll figure that out. We'll take, like Scott said, we're going to break this up. We'll likely take a 10-15 minute bio break at some point, depending if this is going long. If it's not, then we'll just plow through. I'd ask that if you can, save your questions and then use the raise hand function to get into a speaker's queue when we come to the Q&A sections. as opposed to using the chat. I won't be monitoring the chat. I won't be able to see when I'm presenting this document. So someone will monitor the chat if you do, like if you're unable to use a microphone or whatever, but ideally if you can avoid the chat as much as possible. Yeah, and then there are some standard provisions in here that I'm going to sort of not spend a lot of time dwelling on. They are, like Scott had suggested, sort of, boilerplate type things that we won't have to bargain later. In normal situations with a collective agreement that's established, we're probably presenting you, 10, 20 revisions to a collective agreement and going through those. We have to go through all of this. This is from nothing to this full agreement. With that, I'm going to share my screen and I'm going to start going through this. Now, you all should have also received this in an email that went out yesterday. Hopefully, you've had time to look at it. The memorandum of agreement on the first page here is just essentially the cover page for the total agreement. It lays out some of the legal language around the agreement. That everything that's appended here is the agreed to language. The agreement runs until April 30th, 2027. We've recommended to our parties, so we're going to recommend it to you. The University Bargaining Committee takes it back to their Board of Governors for acceptance. And we'll jump in. The way I set this up, I put the document together based on when we agreed on things in chronological order. So the final version of the collective agreement is not going to look like this necessarily. It's subject to, numbering and layout and correcting any sort of grammatical errors, typos, that sort of thing. But the language is not going to change. This is what you are voting on. It'll just be how it's laid out so it flows. So purpose and recognition, again, I'm not going to waste time on it. Just basically an overall, like, this is sort of what the point of this is, to set the tone for relationships between the parties. Union security deals with union dues. When we get them from the employer, the information we get alongside them, and then if there's changes, how much notice we have to give them. The union information, again, goes along with a bit with the dues, but this is the stuff, and there's a lot of stuff here that we're getting. The reason we get that information is so we can properly communicate with our membership. This is not, this is legally required stuff. They have to provide it. We're just putting it in here so it's clear what they're going to give us. It allows us to track the make of our membership, how to get a hold of them, those sorts of things. It also gives us a chance to sort of identify trends, what people are getting paid and, when jobs are being lost, those sorts of things. And we get it in a digital spreadsheet. And then correspondence is, again, just sort of how, messaging is passed back and forth between the union and the employer. In this case, the president, the recording secretary, and then the director of employee relations and planning, or some other designated employee, and then the national representative gets copied. Management rights, again, standard language. Before this collective agreement, management held all of the rights outside of legislation. This explains what their rights are as checked by this agreement. So anything in this agreement that sort of curtails these rights, that's how this works. So this is not, this is in every collective agreement. You can have a look at it. And then, that they have to be, they can't be arbitrary, discriminatory, or bad faith, which again allows us some leverage to grieve, and incorrect use of management rights. The Labor Relations Committee, this one, it took us a while to get through, but because the employer wanted two committees, they wanted one for Unit 0 and one for Unit 1. We pushed hard because, we're trying to coordinate the two groups. There's a lot more strength in the two groups together. So they finally gave and are allowing us, the 6 representatives, to form one committee. And then I think the important thing to flag is some of the information that they are required to provide for us, and we'll get to, there's another bit of language later on, but essentially these are the meetings where they have to disclose things to us that are going to impact working conditions and give us a chance to have those discussions and make recommendations and those sorts of things. Scope. This comes from the labor board. So when we certified, the labor board provided what's called an interim certificate, outlining sort of this is who the bargaining unit is, but there were a few exceptions that the university wanted and some things that we were like, no, we don't agree with. So we had to negotiate this. It took a long time, but eventually we were able to get this. We aren't able to bargain this to impasse. So had we not been able to come to an agreement, the labor board would have made a determination on what scope was. But this is essentially, it tells who's in the bargaining unit and who is outside the bargaining unit. And I think the important thing to note is at the end here that there are people that are excluded, staff, postdocs, those sorts of positions. But when when they are hired into do sessional work, they become members of the bargaining unit and are covered by the terms of this agreement. And then union representation just talks about how the union is the bargaining agent for the employees. The employer cannot engage in conversations with individual employees and bind the union to something. It has to go through the officers. And so those are outlined, and there's 7 stewards and 1 lead steward for the unit. And then that they have the right to the staff representative from from CUPE. I'm actually going to pause there for questions. I see Cameron, your hand is up. We'll start with you.
Yeah, I just had a question about that point where a postdoc could be appointed to a sessional and they become part of the union. So that would be sort of like they kind of get like a shortcut in, like they don't have to post that job. They can just be given to a postdoc without any access for us to apply for it. And then now they have the union protections as well. So
no.
Okay.
So they have to apply and be hired in just like anyone else. So
okay.
It's when they apply and they get hired in, then they become a sessional covered by the terms of the agreement, but they cannot be assigned directly into the unit. We will come to language in the posting section around grad students, and we can talk about that at more length, but the employer really wanted postdocs and grad students to be able to access work of the bargaining unit without the posting process, and we stood firm and pushed back hard on that one, and they moved off of that position. So they can't just come in and take your work.
Love it.
Cool. Any other questions before we move on? Cool. All right. The grievance procedure, again, I'm not going to read it word for word. There's a lot here. I think the important thing to really note is that you now have this process to deal with workplace issues. So instead of, these informal discussions you might have had with your department head or your dean or whatever, and it ultimately is just them making decisions about what goes on, you now have the process to file a formal grievance and go through a process which ultimately could lead to arbitration, where a neutral third party will hear the case and make a determination on whether or not the employer is violating the collective agreement or your rights under applicable legislation. So essentially, it defines your grievances for you, your individual, your policy, your employer, and your group grievance. Employer grievances are rare. They do happen. They have that right under the Labor Relations Act. Individual grievances are clearly one you file for yourself. Policy is more of like a broad, the union sees something that impacts everybody or is some gross misapplication of the collective agreement. And then your group grievance means, if there's a number of people with the same situation. There is an informal resolution, which I think both sides understand that this is the best way to try and resolve issues is through an informal resolution. The employer wanted this piece to be mandatory. We were not interested in a mandatory informal process because sometimes that's not going to work, and we need to file written grievances. So it is optional. If the situation warrants just going straight to a written grievance, we can do that. Of course, as always, reach out to your local officers to talk that situation through. The timelines are important, and you can review those, but 21 calendar days for the informal resolution. And then when you get into the written grievances, it's the same sort of timelines. And then they explain who to file the grievances to. If we're filing them, we go to the director of HR or the director of employee relations and the chief human resources officer. And likewise, if they're filing something, it comes to the union president and the national representative. So then we get into the written grievances, and that there's timelines involved with that, the 21 days, and then there's the 14 days as well for filing the grievance, the written grievance based on the response to that informal conversation. If you don't do the informal, then you have 21 days, calendar days, to file the written grievance from when you ought to have been aware. And then there's meeting timelines, and then they have to reply within 7 days of that meeting. So, and then about confidentiality, we're not going to release personal information outside of general updates to our membership about what the status of grievances. And then we have some protections around if you are in a supervisory position over another CUPE member. This is probably more applicable if you have a TA under Unit 1 working under you. We just want to make sure there are some protections that you wouldn't have to essentially attend grievance meetings and act on behalf of the employer when it comes to issues with another member. It just creates a lot of tension and can destroy a local. And then around compensation, knowing that it'll be within 30 calendar days and that we can seek agreement to extend timelines. The arbitration process, again, this is where you can move something to a third party to decide whether the union's right in its issue, or vice versa if the employer is right in theirs. And this just outlines the process of how those people get decided, the rights that they have. They can't amend, alter, modify. Fairly standard, and then that we can appeal back to the arbitrator. And then the timelines again are mandatory, but can be extended with written agreement. And then accommodations, we have language around the need to follow the Human Rights Code and provide reasonable accommodation for folks up to under hardship, and that the union is able to provide representation through that process if they so choose, and that again, everything will be kept confidential. And then persons with disabilities, the same. Disabilities is actually a protected ground under the Human Rights Code as well, but we just wanted to make sure that it was captured specifically, and that there may be some requirement to reassign classrooms and office space depending. Technology and instruction. So this one, it deals with a couple things. You've got that you won't get a reduction in pay based on any technological change introduced during an appointment. It also talks about, if they require additional training, that they'll pay for it and provide it to you. I think the big one for me is C, really, like that any significant changes to overall job duties arising out of the introduction of new technology should be brought to the Labor Management Committee, meaningful consultation. I think that's important to know because of the fact that this could arguably include AI. And so if there is some AI, implementation that impacts your job duties, this is where we get to have those conversations, and they can't just sort of do things on their own independently of things. So I think this article offers some decent protection. It's, again, a really good foothold into additional language as we sort of grow and the local grows and the technology grows. So there's that piece, and that they also will give you an opportunity to demonstrate that you're able to do the work if there's some new technology, and that you won't get denied a position, or you have access to the training through no cost to the university. So fairly decent language there. And then office space and facilities. This is essentially the rights that the union and the members have. So you've got use of the facilities, service equipment, software, library facilities, AV facilities, and then the appropriately equipped classrooms, office supplies, email, printing, photocopying, inter-office mail if it's used, and then you have the ability for accessing the premises to get your mail if it's received, and that if there is mail there for 4 months, they will at least try and contact you before they dismiss it, or dispose of it rather. You've got they recognize that any of the information, the union's information that is stored on any of the university servers, email, those things, that's our property, and they can't just go and access it. They're going to give email access and library access 2 weeks prior to the start of the term, that you retain that, including OneDrive or the equivalent online file storage for 12 months after the end of the term that you taught, unless it's, you're terminated for discipline. And then you can ask for additional time, and they will not unreasonably deny it. You are supposed to get an appropriate office or other working space suitable for private meetings for the duration of each appointment. And if you do not, let your local know, because they were clear that they would make that available. I think the second paragraph here is key, in that if you're able to establish that you met the criteria for working from home and receiving a T2200, which is your ability to claim home office expenses, if you're able to meet that criteria, they will issue one of those forms. This one took a lot of time back and forth with the employer. They really were reluctant to agree to that. They want everyone on campus is what they're saying, but we kept pushing, and they did finally relent and said that basically if you meet the requirements, they will give it to you. And then you got the access to the athletics facilities, same as any other employee, and that you can keep it for as long as you purchased it for. We've got bulletin boards that we can use for union notification. We get an office that's furnished, which we already have, and that we can book university rooms, including AV equipment for meetings. We have the opportunity to meet with all of our new employees, and they will provide us information as to who has never worked in the unit before, so we can reach out to them. And that everyone has reasonable access to gender-neutral washrooms. So that is that. And at that point, I'm going to take a break and open it to questions again. And if the bargaining committee has comments as well they want to share on anything, feel free to jump in. Oh, Scott, go ahead.
Sure. I just wanted to point to the T2200. So the definition of T2200, and I'm going to do the sort of speak to your accountant preface before I get into the T2200. The definition of a T2200 is 51% of your time 51% of your work is done from home. So And we have agreed with the employer 180 hours as the duration of the term. And so if you're able to subtract, your lecture hours and your office hours where you're actually on campus, and that ends up being less than 50% of your time, then you're eligible to write off a portion of your expenses at home based on the square footage that you're declaring as your home office. This is basically a large raise that costs the employer nothing for us to be able to write off our taxes this way. But this is something that's going to have to be documented. It's never been done before. And the onus is on us to approach as individuals our own director of the program to notify them and to get permission on this. They have to accept it individually. So this is something that I'm expecting is going to lead to a series of grievances, just to clarify. But this is something that I think that I'd like the membership to begin to implement starting in the spring term. Jessica, your hand is up. And you've done, there we go.
Hi, friends. It's nice to see you. I have two questions, if that's okay. One is on accommodations and one is on the office space. So just as you were walking through the document. So the first question about accommodations is just sort of what is the general process for accommodations? So is that something that would be handled through like an online portal, such as to submit documentation? Or is there like a specific person who would handle that in terms of a heads up?
Yeah, so there is a department on campus that handles accommodations. So you submit your need through them, and then they provide as much information as reasonably necessary to your supervisor to maintain that accommodation. So they're not getting into your medical issues and any of that, but they have to communicate essentially if your restrictions are that you can't walk upstairs, then they have to be able to say they have to be put on a first floor room or whatever. So but it is done through their office on campus, and I can get you that information, or Scott can get it for you. Yeah, thank you, Sarah. I believe that's correct, but we can find out. And then, does that answer that question for you?
Yeah, so I think it was very helpful. I think somebody said accessibility, and that was going to be my follow-up, so I appreciate that so much. The second question is office space, which is, will we be moving to individual offices versus shared offices? And I mean this completely without tone. There was a spot in the document, though, that mentioned for a suitable space for private meetings. So I was just wondering if that means like private office, or as long as you're coordinating with people in a shared office, that's fine.
I mean, it hasn't been tested yet, but if you need a private room for a private meeting, you should be asking that question of the employer and saying, I need a space to hold this private meeting, and they're supposed to provide it for you. And if they don't, then I think you take that meeting from home, do it virtually, and then that adds to your hours working from home.
Okay, thank you so much.
But I would also, if you are denied a private room for a private meeting, I would bring that to your local, because we need to bring those issues forward.
Okay, thank you.
Cool. Any other questions? Okay, seeing none, I will move on. So academic freedom. We took some of the language from the FAO agreement and tried to work it in here as much as we could. You will see that you have some right to provide, you'll see the definition of academic freedom there in C. You are, of course, required to deliver the course material, but you are able to, provide larger political, cultural, philosophical ideas related to the assigned courses, and without institutional censorship. And so it does go on and see there to talk about that you can alter the delivery of courses in extenuating circumstances. You need to get supervisor approval, and but it does not give you the right to change the overall delivery mode. And then, of course, you have to, when you're expressing things privately, you have to make sure that you're not coming across as a representative of the university. Your Labor Relations Committee, this is in addition to the previous article, and this is the one where they have to disclose an estimate of the number of employees in the bargaining unit that they intend to employ in each fiscal year. And that if there's any substantial changes that come after that meeting, that they bring it to the next Labor Relations meeting. So essentially, they'll give us the estimate in the spring, and then if they estimate 300, and then come fall it's 200, they have to bring that information back to us. And then the point is to allow us the opportunity to discuss, and the employer needs to consider any of the proposals that we bring forward that might mitigate the impact and or loss of work. Discipline. Make sure I'm good to carry on. I am. Okay. So again, discipline, just cause only. They can no longer just terminate your employment for no reason. There is a progressive discipline that they've agreed to enact. It doesn't mean that, if you do something super egregious, you walk in and you throw a chair and hit a kid in the head with a chair, you're probably going to get terminated, still subject to grievances. But basically, like, they should be starting with a verbal warning all the way up until they get to dismissal. So there should be some path for you to understand what the issue is and then correct that behavior. That they can suspend people with pay while they do their investigation if there's some sort of health and safety risk, but you will get paid if they do put you on any sort of leave. You're entitled to union representation, and if you choose not to use union representation, we do receive notice of that, and then you have to get there has to be a meeting to discuss anything before they give you any discipline, and then they will give you some advance notice of that meeting. And they have to give you written notice after the meeting, and that the union will receive notice of that as well in written correspondence. This essentially gives the union the ability, if you choose not to take union representation, although I highly recommend you always take union representation. If you choose not to, at least we know about it so we can follow up to talk about your rights in the grievance process. And then you don't have to go through the informal process if you are disciplined. The informal discussions, those are not disciplinary, so coaching, sort of recommendations, those things not considered disciplinary, but they will come off your file after 12 months. If there's no further informal conversations. If you have more than one appointment, they can, and it's serious enough, they can dismiss you from both of those appointments. And then, again, the protection for if you are a supervisor over another CUPE member, that you don't have to be a part of the discipline, and you can just bring those issues forward, and somebody above you will take care of the discipline, and that you won't suffer any penalty in employment or your academic standing for exercising any rights under this. So, if you're a supervisor and you choose not to discipline someone, but rather just bring it forward and let someone else take care of it, they can't do anything to your employment, nor if you happen to be a student as well, and you happen to be working as a sessional, they cannot do anything with your academic standing. Health and safety. So you have the right to a safe workplace. Both parties agree to that, and that they'll take they'll use the precautionary principle that, and they'll take any reasonable precautions under the circumstances. And that you can't be required to or act in a manner that breaches the Health and Safety Act, and that they will abide at all times by their employer policies around health and safety. They will provide employees with the protective equipment they need, and that you have to use it. They will also provide CSA-approved CA95 and 95 masks if you want it and you ask for it. And then they will ensure that appropriate air quality is provided to all buildings, applicable to legislation and regulatory standards, and that you can raise those concerns as a grievance if needed. And then we have the right to attend any of the training programs. We also have union membership on any joint health and safety committee that's been created for both units. I don't know, and Scott, you can clarify, I don't know if we currently have someone from Unit 0 on the committee, but we do have that right to have someone on that committee, and that's where our health and safety issues can come forward, especially air quality stuff, any of the campus safety issues. We can bring those forward through that committee, and they will make sure that the members are certified, which is a specific training under the Health and Safety Act, and that you will be able to complete your required health and safety training during the working hours. We also have some language later that deals with paid training. So, employee privacy. So we've got some stuff here. Here's what electronic monitoring means. The digital collection relating to physically entering the university workplace, operating, it goes through that list. And that digital data means any personally identifiable digital information related to bargaining employees collected directly or indirectly by means of electronic monitoring. And that they can collect digital data for only these specific purposes. Again, safety and security, the university committee, their facilities, their assets, digital devices, safeguarding the confidentiality, time tracking, authenticating and maintaining the integrity of the university's financial transactions, financial, physical, and electronic management of university resources, any other purpose required by law, and for any purpose for which the university is permitted to share digital data pursuant to 12E, which is our grievance language. And then, unless required by law or permitted by this agreement, the university shall only use digital data related to bargaining employees for the purposes which they were collected. Outside of some exceptional circumstances where health and safety, the example the employer used was if they knew someone was a risk to themselves, they may have to release to law enforcement where you live and have you checked up on. That was the example they used. So, and that they're not going to electronically monitor anybody for performance management or discipline. If they do discover through independent means that there's some sort of disciplinary or performance issue, and including if they discover it through the course of collecting digital data, they may use that then, but they have to notify you in advance of digging into any other additional electronic data or digital data rather, essentially giving you the chance to speak to, and I'll be with you in 1 second, Dan, just let me finish through this. So they have to give you the chance. Essentially, they need to do some investigation on their own before they start digging into the other stuff. And then it won't be arbitrary surveillance, audits, or assessments. They shall not trade or sell any digital data to any third party. They won't share any digital data with any third parties unless required by law or required for the provision of services by third parties, or permitted by this agreement or with the employee consent. And then employee digital data shall be stored and handled in compliance with applicable federal, provincial, and or municipal data protection and privacy laws. I will break for questions. Dan, your hand is up. I cannot hear you, Dan. I don't know if you're talking.
Are you, am I unmuted now?
Yeah, you're very, very quiet though.
Okay, so let me see here. Is that better? Worse?
Yeah, no, that's better.
Okay, quick question about the health and safety training.
Yes, sir.
And basically, I think I broke the system. I've been a sessional a long time, and I understand I have to do the health and safety training. So, I've gone about again in the fall and did the training. And then, you register that you've completed it and you've passed the test and blah, 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 blah. And then you look at the site and it says you haven't completed the training. And so I did it again. And okay, here we go again. So then I finally called HR, and what they figured out was it only registers the first time you complete the training. So I'm just thinking, what happens whenever I do the training now is I send an email to HR saying, look, I've completed the training, but it won't register today's date because it only registers the first time. So I'm just as a protective piece, either the university has to clean that up, or we as members need to make sure that we track that we've done the training and send an email off. Just if somebody says, well, Dan, we're terminating you because you haven't done the health and safety training, I'm going, well, I've done it 3 times now. So just a caveat to throw out there.
Yeah, no, I appreciate that, Dan. That's good to know. And I would suggest, like the local can take that forward. Maybe if you don't mind putting that in an email to Scott, and we can make sure we follow up with HR. But if they do down the road try to discipline or end your appointment because they claim you haven't finished your health and safety training, and it's an issue on their end, we'll deal with it through the grievance process. It shouldn't be an issue, but they should be cleaning those things up 100%. I don't disagree. And one of the things they did say, a bit sort of general comment, was I don't know that they were excited about having a union on campus, but they did recognize that having a union here will help to streamline and add some standardization to processes. So I'm hoping that some of these issues as they come up will get it resolved, because right now things are far too decentralized and a bit rogue. So to your point, I'm hoping that will clean up as we get through this. Natalie, I see your hand is up.
Hi there. Can you hear me okay?
Yep.
Yeah. I just wanted to follow up on what, is it Dave? Dave said? Or Dan?
Dan.
Dan said. I had a similar situation, and it doesn't only affect employees or sessional instructors. I taught a fine arts course in the fall, and all students and staff have to do safety training, a couple of modules on WMIS and other safety concerns. And a number of my students came forward and had the exact same problem. And I did as well. And so whenever you do training like that, make sure that you take a screenshot of your completed. Usually at the end, you get a completion page. Take a screenshot of that, and I passed it on to my department chair along with my students, and they were able to get it rectified through a back end. But you're not the only one that has had problems with that. So I think it's something that the university definitely has to address.
Perfect. Yeah, thanks for that. I appreciate that. Go ahead, Scott.
Just two things to follow up, and Tim will get to this part later, but we've also negotiated an hourly rate for to be paid to do training. We'll get to that. I want to go back to the point E above in I think in the category health and safety, Article 16. Item E, the subtext for item E here in 16. Yeah, there we go. The subtext of this one is basically COVID, but there are other atmospheric, diseases like just the straightforward flu or smallpox or whatever. We bargained this one long and hard, and we came down to this as a kind of joint agreement. We are probably going to be filing grievances in the next year with regard to the lowest quality classrooms, and we'll be doing that as a test. We might be needing some help from some of our members on that. So just as a kind of a flag for that this is going to be our toehold into that. And then the other thing I wanted to say is that yes, we have 2 seats as CUPE 5524 on the Joint Health and Safety Committee, one for Unit 0, which is Sessionals, and one for Unit 1, which is TAs and RAs. Right now, our Unit 0 person just stepped off, and so we have a position available if anyone is interested in joining that committee, the Joint Health and Safety Committee for Unit 0. Anyone can email me if they're interested, and thanks.
Thanks, Scott. Yeah, I appreciate that clarification. Any further questions on the section we just went through? No? Okay. I'm going to get back to where I was. Okay, discrimination and harassment. So discrimination talks about all the grounds that would that they cannot discriminate someone for. There was a few in here that go beyond your protected grounds in the Human Rights Code, which adds a little bit of extra protection. They've also, agreed that second paragraph talks about physical attributes. That's, again, outside of the Human Rights Code, but they've agreed to that they wouldn't discriminate. And then the visa immigration status, they took a long time coming around to that. Clearly, we understand that there has to be a legal ability to work here, but they cannot threaten or coerce anybody using their visa or immigration status. And there is agreement that no one will be penalized in their student or employment status for exercising their rights, for whether they're under this agreement or for being a member or non-member of the union and their activity as a member, and that you have the right to be referred by your specified pronouns, and that any intentional refusal to refer to that person's specified gender pronouns constitutes discrimination or harassment. The harassment language, you have a right to a harassment-free workplace, and then there's the definition of what that looks like and what sexual harassment is. And then there's the harassment complaint procedure. So the university has policy 33, which you can exercise your rights under that. You also have the ability to file a grievance around harassment or discrimination. I'm not going to tell you which avenue to go, but I will note that your grievance process has much tighter timelines associated with it. Ultimately, they still have to do an investigation, but my advice to members is always, if you have access to the grievance procedure, you should use it for these types of things, as opposed to using their policy, which can take a long time to work itself out. They have the right to separate the complainant and respondent. Nobody's going to suffer a financial loss. And if they have to separate you, whether you're put on a paid leave or maybe you're moved into different assignments, whatever that looks like, those aren't grievable, except in cases where the complainant feels that the interim measures don't actually create a safe workplace for them. And then this is where we get into timelines, where again it talks about some of the, it refers to our grievance procedure around those timelines, but you can grieve the interim measures within 21 days. Your actual grievances around discrimination and harassment can be filed within 12 months or longer if there's compelling reasons or sexual violence. So you have much longer in order to file a grievance on those pieces. However, once you get the results of whatever the investigation is, if you disagree with them, then you are bound by the timelines under the grievance procedure. So let's say you bring forward a discrimination complaint. They do their investigation. They come back and say, yeah, we've got no findings. We're not doing anything. And you feel like the investigation was flawed, the results are incorrect, and that you still don't have a safe workplace, then you can file a grievance, but it has to be within that 21-day period. And then, yeah, no reprisal. You bring forward a good faith complaint, you cooperate in investigation, they can't do anything against you. Professional advancement, we've got, again, a toehold of language here. You're allowed to apply and be considered in the same way as any other candidate. And you also have the right now to request a meeting with your academic department head to review career possibilities and how you could advance your career. Intellectual property. So you have the right to ownership of intellectual property subject to the list of exclusions. And then you're governed by policy 73, which is pretty robust. And then if they do big changes to that policy, they have to come and consult with us about that and the effects of it. And your evaluation employee files. So you have to be given 2 weeks notice before they do any sort of performance review or evaluation. And then they have to also provide you what aspects will be evaluated. And that evaluating you is part of management rights. And that if they change the use of or implement any new or formal student opinion surveys, that they have to have meaningful consultation with the union through the Labor Relations Committee before implementation. At the table, they said that they do not currently use student opinion surveys as part of evaluation. And Scott can correct me if I'm wrong. I believe this was the day Ryan was there. That is my understanding, though, that they do not. So if they decide to, they have to come in and provide that update to us and have a conversation about it. Scott, am I right on that?
Yes, what they said at the table was that these opinion surveys are used to evaluate student experience and not quality of teaching.
Awesome. Thanks, Scott. You also have the right to request a performance evaluation if you so choose, one per appointment. They cannot unreasonably deny it. They cannot place any formal evaluation in your file unless it complies with A, B, and C above. And then they have a list of items that will be in your employee file. You will see those there. And it is noted that the disciplinary and those things come off your file. Relates back to that article where they will be removed after 12 months. Academic records, not part of your employee file unless they're submitted as part of an application. They have to tell you when they're putting things on, in your file. You have the right to request a copy of it. You also have the right to dispute things that are in there, put in your own words. Doesn't mean that they're necessarily going to agree with you, but you have the right to append a disagreement into that file. And then dossiers, you have the right to access the photocopying, printing services in order to prepare applications for research grants, scholarships, and other academic positions. And I think I will break there and open it up to questions, if there are any. Okay. Moving on, no strike lockout, pretty standard boilerplate type language, but it took a long time to get here. They wanted for a long time to have us agree that we could do work of other striking bargaining unit employees. There was a massive fight over that. Eventually, we just ended on whatever the Labor Relations Act says around strikes or lockouts, that there will be none while the agreement is in operation. So basically, for the term of this agreement, you cannot strike and they cannot lock you out. Holidays, you're not required to work on any of these days listed. They wouldn't give us the National Day for Truth and Reconciliation, as it's not currently a provincial holiday, only a federal holiday, and they don't recognize it, but they will make best efforts to accommodate folks that do want to observe the day as much as possible. And then you have the floating days around Canada Day and Christmas, New Year's, and that you're not going to be required to work on any day that the university is closed. And then if any other day is proclaimed by the provincial government as a statutory holiday, it will be added to that list above. So if the Ford government decides it will recognize the National Day of Truth and Reconciliation at some point in time, which would be really nice, then that would be added to our list. Union leaves and entitlements. So this provides some protection for the folks that work on the union executive and may be limited in their employment abilities, that they will protect your seniority. And B is around getting an extension to your program limits. If you serve on the local executive bargaining committee, you go work for CUPE Ontario, or sorry, you're elected to the CUPE Ontario executive, national executive, or the OUWCC, which is CUPE Ontario's University Workers Coordinating Committee. If you get elected to that, you can apply and get an extension. Again, this may not apply to everybody, but there are grad students that may end up working in this unit, so we offer some protection there. They will give you up to a week of union leave without loss of pay for 3 actively employed members per term to attend conventions, conferences, training. So, the national convention is every other October, and the Ontario convention is every May. So you can get a week off to attend those things. You have to find a replacement, but they also will assist in arranging that if needed. And they will make
Tim, can I just quickly jump in?
Yeah, absolutely.
Yeah,
Katie.
so I just since for some of you folks this might be your first time that you've been in a union, I would really recommend putting yourself forward as a delegate to attend the CUPE Ontario Convention or the National Convention. The way CUPE is structured is that it's entirely member driven. Decisions that the union, that the national union or the provincial wing of the union makes, that all comes directly from our membership. So decisions are made at those conventions. It's really quite fascinating. I can sit in, I'm not a CUPE member, I'm obviously staff, so I don't have any voting rights or anything like that, but it is very fascinating to be able to kind of watch how this works in practice. So I would really recommend, first of all, I would recommend that you work to join your executive, become a steward, but also if you have the opportunity to attend one of these conventions, it really is quite interesting, and you really do get to have a say in the directions that the union takes.
Yeah, thanks, Katie. No, that's super helpful. I appreciate you jumping in and adding that clarification. Yeah, and so we do have some provisions in here. Attending strike votes, ratification votes, that they'll make it best efforts to let you attend those. And then we have language around if you get hired by CUPE National or CUPE Ontario, that you will continue to be paid. The employer gets paid back through the national union or Ontario, and that you continue to accrue seniority up to the end of the date of the appointment. Your negotiation procedures talks about how many bargaining committee members there will be. We're looking at 8. the rationale there, one per faculty, right, Scott? And then what were maybe why don't you speak to it, Scott?
Going by memory, one per faculty, so that's 6. I think the president is 7. We have satellite campuses is 8. Would that be right?
That sounds vaguely familiar. Yes, that's where, and it did come out of the local bylaws. How we came with that number. Yeah, and then we try to avoid conflicts with the work. But if not, then they will, assist with making alternative arrangements for replacement. And then you have the right to, an advisor, business agent, staff, administrative assistant, and or a national representative through the bargaining process. Participation in departmental meetings. So you have the right to participate in any departmental meeting that includes all the departmental employees, and you have reasonable opportunity to participate on appropriate departmental ad hoc committees and working groups. So you have access to that. I think that's helpful, and you should get involved with your departments. Your teaching assistant support, again, as a sort of toehold. So you will get assigned a TA on the same basis as anybody else, any regular faculty, in accordance with the policies and procedures. And you also have some ability to raise issue when there's not enough functional seats and or work writing spaces available, and that they will have to address those things. And if you give me one more second, I'm just going to get through this last bit here, and then we will take a break for questions. The territorial acknowledgement, I won't spend a lot of time. That was what Scott read at the beginning. This will go essentially at the very beginning of our collective agreement, something we thought was important to put in. Employee duties lays out sort of what the general role that you have with the university, and sort of the term of the appointment. So it starts the 16th of the month prior to, it goes right to the end of the appointment. The expectation is that you are not working beyond the last day of the appointment. So if there are grade appeals that come in post, December 31st, they are supposed to go through the department, which is why you have to provide the records to the department. If you are required to do any work post appointment, there's an hourly wage that we've negotiated that would be paid for those things. But the employer has said they will not expect anybody to work on anything after the appointment ends. And we call bullshit on that, pardon my language, which is why we needed to make sure we had something in there that if they do make you work, you will get paid for the time spent doing work post-appointment. I think that's sort of the important piece in this section. And I think, yeah, I'm good here. I will break. Jessica, I saw your hand up first, but you put it down. Do you have a question?
Yes, I still do, if that's okay.
Yeah, no, go nuts.
Thanks in advance for listening to all my questions today. Y'all are amazing.
Yeah, no,
this one is about, I think it was Article 32. It's the one about the department meetings.
Yes. Just jump.
Yeah. So for that question, it's currently in our department, sessionals are allowed to attend what we call the open portion of a meeting. There's also a closed portion where we're not allowed to currently attend that. And so my question now is, are we allowed to also attend the closed portion of the meeting, or is that still for more, I'm going to say like permanent faculty? And are we also now able to start serving on committees?
So I guess I would ask you, in the closed section of your departmental meetings, are all departmental employees included except for sessional faculty?
So the closed portion would not include sessionals, graduate students like TAs, things like that. I think it's currently like permanent faculty, but yeah.
So that's interesting. I guess we made like this.
Does it include administration staff?
Yes, they're there as well, taking notes, for example.
So I would say arguably, we can make the case that you have a right to attend the closed section if it includes all the departmental employees. But it may come down to like if they make the argument that because the grad students aren't included, that doesn't include everybody, and so you don't have that right. But I think that's an interesting question, and it should be you should try and assert your rights under this collective agreement to be there. And if they deny them, come talk to us, and we can deal with it through a grievance if there is merit to it.
Okay, so would the answer sort of next step be taking this to, for example, the chair and showing them Article 32 now and saying, does this allow us to attend the closed portion?
Yeah, so when this gets ratified,
Yeah.
and it's in place, then yes, I would make the claim that you want the right to attend the closed portion, and then if they balk, then I would refer them to. And again, right now it's numbered Article 32. It may not be 32 when the final draft is done, but I would refer to that language. And if they deny it, then yeah, let us know and we can help you through a grievance process.
Okay, thank you. That was very helpful. I appreciate it.
Your second question around committees, I would say yes, you have a right to be participating in committees now. That's how I would read it. But again, like if they say no, then we'll deal with it that way.
Thank you so much.
Yeah, no problem. Jonathan, you are next in line.
Hi, I'll try to be succinct, but several questions have come up even in the last couple seconds. With regards to committees, my department has always said there was a committee that I wanted to be involved with for the benefit of the students, but they've told me over the years, well, we can't ask you to do that because you're not paid for it. So is there anything in this contract that would mean we would be, I assume we would not be paid more to join a committee and participate in that kind of activity?
Yeah, we didn't bargain language that would entitle you to be paid for that time. So no, you probably wouldn't get paid more at this point. I mean, that's something that we could certainly look into as we move ahead. Yeah.
Okay.
I'm just going to interrupt. I might budget those hours against my 180 hours of the term, and see if you could make the argument that you are paid for it in the time that you give.
Okay. That of course is our discretion whether we're going to decide to be on a committee or not. Another question my first question that came up is the word seniority came up in the last set of descriptions. What does seniority mean for us when we're hired, for a term, and it's kind of like it resets every time? Does seniority apply to us within the kind of view of whatever faculty or department we're working in, or in terms of our CUPE membership?
Yeah, so great question. We will get to seniority. It's referred to in a different article that we will come to in a little bit. Yeah, and it'd probably helpful if I wait, but you do have seniority now. That is a right you have, and it's based on completed appointments, and we were able to get them to date that back to your first date of hire. So all of your completed appointments from day one, even before we were certified, all of that time counts towards seniority.
Cool. I'm excited to hear about when you get there then. Thank you. I got two more quick questions that are related. We're talking about after-term work in this block of ideas, and I frequently get student appeals emails where the department asks me to. It's a giant pain in the butt. Like they really ought to automate it better, because I have to go into Learn, and sometimes after my appointment, logging in is more difficult. I have to get special permissions sometimes. Then I have to fill out this super long form, go back, find the student's information. They want you to fill out what percentage of the final grade every mark was and what the student got on it. And it's a lot of work. For a student, it takes about an hour to go through and do that. If it's after term work, according to this new contract, how would we manage that? Would we like send an invoice to the department? Because I'm used to sending invoices as an independent contractor and other kinds of work, but through the university, everything's, I get paid with a T4 and all that kind of thing.
Right. Yeah. So when you're receiving emails requesting you to do additional work, I think the first step is going to be flagging back to your supervisor, as like eventually this is going to become sort of normalized, and everybody's going to be fine and know what they're doing, and it won't be weird. But right now it's probably going to be some hiccups along the way. I would follow up and say, look, like, I'll do this work, but you got to refer to the hourly work provisions. This is beyond my appointment. I'm going to expect payment of X amount of dollars for this time, and then send in the tracking when you're done. Be like, I worked on this particular grade appeal from 8 a.m. to 10 p.m. I mean, clearly that's excessive, yeah. But you know what I mean? Like you need to track that and then send that back into the person that's requesting you to do the work. If they do not pay you or they balk at it, got to get a hold of your union so we can file grievances on it.
Okay. And the last one for after term work, I'm not sure how often other instructors may have encountered this, but in the past I've engaged in with students on incomplete ratings for their semester, where they had some kind of medical issue or mental health issue, and there's maybe a couple of assignments that they can make an agreement with you, the instructor, on to complete outside the term. And if they complete those assignments to satisfaction, you can pass them in the course that they otherwise would have failed, meaning they don't take the course over again to complete their degree. Those, I suppose, if in the past I've just done it out of the goodness of my heart through the summertime a couple of times, but now it would be like something I'd need to talk to my supervisor or department head and sort of define the boundaries a little more, I suppose. Like it would likely require your supervisor to approve that time that you'd be doing that. I think what they think will happen is that someone else will take on that role. Some sort of permanent faculty will take on that role within the department to deal with those things after the appointment ends. I think in reality, it's probably still going to come back on you, and then you just have to claim for those hours worked in that. But you would need some approval from your supervisor to say, yeah, go ahead and do that, or we'll get someone else to do it. Great. Thanks very much for answering my questions.
No worries. And I guess subject, everything I'm saying doesn't mean that the employer is going to take the same position. And that's why we have a grievance procedure now. They might say, no, that's not how this works. And so we have to hash it out that way. But that is my advice to you right now. That's the way I understand the language, the way I understood our conversation at the table. So, but I want to caveat that I don't make the decisions at the end of the day. The employer, they make the decisions. And so if we disagree with them and we feel it violates this agreement, that's why we have grievance and arbitration.
Great. Thank you very much.
Yeah, no worries. Dan, you are next. I cannot hear you again, Dan. Sorry.
Student course perception surveys. Can you hear me?
Barely.
All right. I don't know what's going on here with
that. Yeah, no, you're better. You're better now.
Okay. Just a random question. It may not have an answer. The student course perception surveys. I just find it an interesting, perhaps a waste of the university's money that could go elsewhere. I'm thinking I look at them as a form of personal, professional development. Okay. Sometimes the kids have some really interesting insights. I go, I didn't realize maybe I should try looking at this a little differently. But again, that's me. If the university isn't using that as part of their portfolio for hiring, right? I mean, we've got some tremendous sessionals doing outstanding work, people I'd love to sit in their class and watch them. Why don't they use those? And I get it's personal privacy issue, but I mean, if the university is using them for only kids are happy or unhappy, but we don't use it as data to hire more efficient and better instructors and maybe let less efficient ones go, what's the point of even having these things?
Let me answer that question. So it's been demonstrated that these student surveys are biased with regard to race and gender. And so from an equity point of view, we can't be using this information that's biased in terms of evaluating teaching quality. And I will also say that since they've moved from handwritten to digital student surveys, that the participation rate has dropped from about over 90% to somewhere closer to 30%. And so even the sample size is not helpful. And so in the end, what good is this data? This data is basically only good to determine what your students experience during the course. And I can tell you in terms of some previous work that we've done with the university on these student surveys, all you need is a half a dozen students who have a real problem with the professor to really torque these surveys in the wrong direction. And so the fact that they just don't work that well from now on going forward is not the union's problem and not the employee's problem.
No, that's fair enough. I guess the question then becomes, we've got all these bills we need to pay. So why are you investing in something that's really of no use to us, right? So, all right. Thanks for your time.
Yeah, no problem, Dan. Benjamin, you are next.
Yeah, thanks. I just wanted to follow up on the departmental meetings and committees. So
Sure.
I think you had mentioned 180 hours. Maybe we'll sort of explain that later. But I was wondering again, so how would that process work? I think I'm sort of clear on like the extra stuff we do after the semester. But like if we got put on a committee or volunteered for that, what would the potential process there be to get paid for extra time?
Yeah, at this point, I don't know, like volunteering for a committee is not necessarily going to generate extra income. We use 180 hours, but it's sort of, that's a loose, we don't really define hours of work within the agreement. We define a rate of pay for the term being, the 16th of the month prior to, and then the last day of the month that the appointment ends. So, I mean, if you choose to volunteer to be on a committee, likely is not going to generate extra income unless you budget that into sort of your the time you're already working. So if 1 week you have a bit of a lighter load and you spend a couple extra hours on the committee, that's sort of how that would get addressed.
Got it. Thanks.
Yeah, no worries. Sarah, you're up.
Can you hear me?
Yep.
Okay, I'll be super quick. Leave time for members. Yeah, during the committee section, or right after, you said something about like if there wasn't enough writing spaces or something like that, and I didn't catch what that was, but I didn't understand what that was referring to.
So it's currently Article 36B, and it talks about if you believe that there's not enough functional seats and work writing surfaces spaces available in an assigned classroom.
So to prevent overcrowding, basically.
Yes. Yeah.
I gotcha. Okay. Thank you. I appreciate that. Yeah, and then just super briefly on the other questions about the committees, I think it sounds like it was approached to start as more like a right to take part as opposed to a right to be paid, if that's kind of how, because like a lot of times sessionals might get excluded from kind of the academic life of the university despite full qualification to be arguably, but formal qualifications to be a faculty member. So I know that one of the bargaining committee's members, Jeff, had mentioned to me that like one of the departments, they wanted to basically allow every single employee to attend a meeting except sessionals, which to me is just insane. But yeah, maybe in future there could be more specific provisions for that. But I mean, I think in any workplace you're allowed to join like social committee or those kinds of things and like have them be during your work hours sometimes or not necessarily get paid. So yeah, but that's kind of how I kind of understand it if I'm not wrong.
Yeah, I mean, it depends on the
Does that
committee.
make sense?
Like
Yeah, for sure.
the Health and Safety Committee is a legislative committee, and there's language in that act that talks about, you will get paid. This is considered work time.
Right.
But
Yes, yes.
a one-off social committee may not, generate the
Yeah.
same, because it's not there's no legislative requirements. But again, this is a starting point, and we want to make sure that people had access to their department meetings and committees if they wanted them, which we were able to get a toehold in.
Yeah, that makes sense. One last quick question for the perception surveys. There was the question about why not use them, and so I was wondering all the caveats about their biases and all these things, but in theory, you would, as an employee, be able to opt to use some of that information in your own performance review, right? Like you could say oh, I got these great ratings from my students, or they wrote comments about how I was, gave engaging lectures and how they learned so much. In theory, you could still choose to use that information if it's quote unquote good information, right?
Oh, for sure,
It's just
100%.
that the employer
right.
can't
Yeah,
force you
exactly.
to
That's 100%. So if my student surveys say across the board that I mumble, I will try harder. I will try harder in the future to speak more clearly. But the employer is not going to be able to sort of say, we're not going to hire you back because you mumble.
Gotcha. Okay, that makes. Thank you.
Okay. Covey, you're up.
Yeah, I also just wanted to throw in my 2 cents or sort of questions around the student perception survey stuff. I think the language you described makes sense, and having input is definitely a good thing if they ever change the system. But I kind of agreed with Sarah's and Scott's comments just there, and to Dan's question, especially for PhD students or people who are sort of looking at the next job opportunity. That feedback is both pretty useful for our professional development and can play a role in applications and teaching letters and so on. And so I think this is good for now. It's something to think about over the longer term, like how to represent those interests, I guess, like our interest as workers in both receiving accurate student feedback and in I think there's connection to some of these pieces about access to records and these other sorts of things that could help us. And then I think the issue around hiring there is an interesting one. Again, I don't know if we have direct answer to it as a contract, but there is a bit of a conflict, I think, in that on the one hand, we know that there are these perceptions of bias and or there are these evidence of bias in these pathways, but just that because that relationship between in this workplace between us as instructors and with students is a very important one, right? Both for the work we do, but also for the sort of community support and legitimacy of the union in a way. I think it's an interesting issue. Again, it's really a comment, but it's just an interesting issue to think about what the just and equitable way to reward good teaching by sessionals is. And I think there are parts of this agreement that touch on it, and I completely agree with the bias concerns, but I do think sometimes the status quo, let's say, is very focused on the sort of top-down evaluation, your network and how your supervisors evaluate. And I think for a lot of sessionals, with understanding of the biases and caveats, one of our long-term goals should be creating more input and value for people whose peer evaluations are positive, from other sessionals, and who have good outcomes in relationships with students.
Thanks, Covey. Nafiz, forgive me if I mispronounced that, but you're up.
No, it's fine. Hello, everyone. This is Nafiz. I have a quick question about the department meeting. In my department, the sessionals were never invited before.
Okay.
So now I was thinking, what I got from your explanation is that we would be able to join. So I was wondering whether all sessionals will be able to join, or the representative will be able to join.
No, any bargaining unit employee is permitted to participate in any departmental meeting. That includes everybody.
That includes everybody. Okay, so that's good to know, because yeah, we never had a chance to attend any of the meetings before.
Yeah, no, for sure. And that's why we wanted to get something in there, because you should have that right to participate.
Yes. And I have another, it's not a question, it's probably my observation. Like,
Okay.
I've been teaching for a very long time, since 2009. And the students' participation, or the evaluation, what I take from that is, I read them very carefully. And when students, give their opinion, it actually, to me, it helps me to prepare next time when I'm teaching. So, there's some constructive inputs there, and constructive comments there, that helps us to figure out how we did, and then we can go forward from there. So that might be something that we consider. But I absolutely agree with everyone that there are biases against, and there are outliers that can tilt the results in one way or the other. But that's just my my input to the course evaluation process. Thank you, everyone.
Well, thank you. Thank you for sharing. Natalie, you're up.
Yeah, I just wanted to build on the meetings and committees, because I think like university wide, it's a deeply kind of departmental tradition, how they conduct like faculty meetings. Because I know in my department, they're very almost secretive. They're sort of hush hush behind closed doors. I've asked to be a part of them. I've been told that you're not paid, even though I've been teaching since 2012. I've said, well, that doesn't matter. I don't mind. And they're like, well, traditionally in our department, we don't allow sessionals in the meetings. So I think, whereas I know in other departments, sessionals are fully welcome, and they're sent, departmental memos about upcoming meetings and stuff. And I think that's something that may be missing in this agreement too, is access to department memos and communications, because as a sessional, I've often been left off of email lists, and I don't actually know what's going on in my department until, say, something happens, and then, oh, well, it was given out in a department memo and I didn't get that memo. So I think it largely depends on like the departmental culture, and maybe having that wording in the agreement will realign that university wide, so that sessionals can assert their right to be at a department meeting and get information about the departments that they work for. So yeah, I just wanted to reiterate that.
Thanks, Natalie. Cameron.
Hi, yeah, I just wanted to make a quick comment, like with what everyone's saying about the student evaluations for, personal growth as a teacher. Like I definitely read all the comments and try and adjust my teaching accordingly. The main issue that I have with that is that I also teach, I teach social psychology and educational psychology, and what students believe impacts their learning doesn't really correlate with what actually benefits their learning. So there's a kind of got to take it with a grain of salt there. But I just wanted to throw out there that the Center for Teaching Excellence on campus offers a service where you can actually register, and they will send someone in to observe one of your lectures and give you a full evaluation with feedback and suggestions. And that can be a really good tool, one for professional improvement, and also as something to present and say, look at this amazing score I got on my teaching.
Yeah, no, thanks for that.
Can you just repeat that? Like where you can access that? Sorry.
Yeah, it's the Center for Teaching Excellence. So they have like some teaching seminars and workshops you can join, but you can also go to their website and actually request someone to come into your class.
Thank you.
Okay. Seeing no further questions, I'm actually going to take a 5-minute break right now because I need to use the washroom. So just bear with me. I'll be right back and we will jump back into it. If there are further questions that come up, and Scott's here, whatever, but I'll be right back. 2 minutes.
While Tim takes a break, if anyone also wants to take a 5-minute hygiene break, feel free. I might do that myself. I will address something that Natalie said, which is we have 48 departments at the University of Waterloo, and the level of autonomy of these departments at the university is greater than at any other university that I know in period. I mean, I don't know a lot of universities, but I know quite a few. And one of the things that this contract is doing is that it's constraining some of the variability of the departments. And so if, as Natalie had said, some departments are happy to have sessionals join faculty meetings, and then other faculties or other departments are extremely secretive. Going forward, sessional faculty have access to departmental meetings in every single faculty. What we are going to find is that there will be some resistance, and that might be conscious and deliberate, or it might be unconscious and ignorant going forward. Our grievance process includes an informal step, and that informal step could be as simple as one of you saying to your department head or somebody in the department, the administrator who organizes those meetings, that you would like to attend and that the union contract gives you that right. Or we could have that conversation at the union level through HR informally to sort of say, this department is resisting this, please make it change, and it will happen. This is something that I don't see it going to a formal grievance. There might be some tricky things when it comes to a closed session. I mean, we hadn't thought about that. The language doesn't address that, but it also doesn't address it from their side either. So I think it's just something that we figure out in the next year before we go back to bargaining the second contract. We're going to be testing out this first contract that we're going through right now through the grievance process for the next year. And in doing so, we'll find some of the parts of this contract that aren't working the way that we thought they were going to work. And the employer might have the same sort of thing. I mean, we'll also go back for things that we got a toehold in this contract that we want to expand in the next round. That's my thoughts. I avoid departmental meetings because why would I want to be in a room with those people? But that's me.
Well, I just want to jump in there. For me, my department had organized a committee around, the use of AI in the fine arts, and it directly impacted a course that I teach and that I developed, and I wanted to be on it to give, my 2 cents on the use of AI in art making. And that was kind of one of the times I was shut down. So I felt like, my voice deserves to be heard, especially when I've taught this course so many times for this department. But I was just given, well, traditionally sessionals don't participate in meetings or attend committees. So this for me is really positive because it clearly states in writing that I'm allowed to be there and I'm allowed to have, departmental information just like everybody else.
Yeah, and to join committees if you wish.
Yeah.
Tim, I'll give it back to you.
Yeah, I just want to flag that I was back, and I'm ready to proceed if there's no further questions on that last section. Okay. Seeing none, let me get back. Go to that. Pension plan. So we were able to get language in here that anybody that is eligible in the bargaining unit for the pension plan can and you may be required, but you can participate in the pension plan. And it's, eligibility is determined on the plan text, and that the employer will notify you if you're able to join or eligible to join that plan, and that they'll make the plan text available. And the one thing I do want to note a little bit around this is that the university disclosed to us through bargaining that they are looking at moving over to the university pension plan, which is a jointly sponsored pension plan. Nothing has been decided yet. I don't know how far, I don't think they're very far into the process in this at all. But I will say that if they move into the university pension plan, that will open up, like if you hold jobs at other universities that participate in that pension plan, you can pool all of those hours to then qualify to be part of that plan. So ideally for you folks, it would be a decent move, especially if you work at, U of T, and I think Guelph participates. Laurier is, I think, joining this year, is my understanding. So anyway, we didn't spell out some of that stuff, but it is something that they are looking at doing. And so they also need consent from the bargaining unit members that participate in that plan to make that change. So just keep your eyes on your emails from the employer around pension plans as we move forward. Again, this is for us a good way to get some language in the collective agreement around pension plans. And it also forces them to look at who is eligible in the plan based on hours worked. And I think they've already started to reach out to folks and get them on the plan. That's the pension plan language. This is a big one.
Cameron has comments.
Sorry, Joel. We were just going to save questions for the next break, but whatever. Go ahead, Cameron. No, it's all good. Go ahead, Cameron.
Yeah, I just wanted to jump into it before we get to, because the seniority and hiring is going to be a big one. Like it's mentioned that it's all by the pension plan text, and I was wondering about the eligibility piece, because regular employees on campus, they have an option if there's a gap in their employment of up to 12 months, they can stitch their pension. And so basically there's a bit of a pause, and then they just carry on accumulating years of continuous service. The problem for sessionals is that if we miss one term, we need to requalify, which takes 12 months. And by the time we've requalified, the stitching has lapsed and we lose our pension. So we're not like a normal employee where we miss one, we jump back in, and maybe in 10 years we've accumulated a total of 8 because there was a few breaks. And if our pension breaks before a certain point, we can't even keep it invested in the pension plan. They just give us a small buyout. So it's very, very difficult for us if we can't have at least one class per term continuously.
Okay, no, fair enough. Again, work in progress. We did the best we could with this language to sort of get something out of nothing. It's not clearly perfect, and we can take away your suggestion and look at, is there a way to accomplish that either, in a year from now when we're back at the bargaining table, or if there's something else we can do in the interim to address those issues.
Can I also just say, Cameron, the pension is something we're going to be working on, and if you would just do me a favor and send me an email, if you'd be interested in joining a committee to solve some of these problems as we move forward to the next round of bargaining. As the university is switching over to the UPP, we have an opportunity to engage and solve some of these problems in process. I think the UPP probably is a great solution for us going forward, and we're really hoping the university is going to go that direction, which they probably will. So yeah, just keep in touch and let's work on that together.
Thanks, Scott. Any other questions on pension before we jump into the next section? Okay. Let's get into Posting, selection, incumbency, and seniority. So I know this one's going to be a big one for folks. Potentially lots of questions. I will certainly open up to Scott, Jeff, or Matt if they have any thoughts they want to add in. But so they're going to post all of the positions. So you'll be able to see everything, nothing hiding. The advertisements include, and there's this list of everything that they have to put on a job posting, so you know what the qualifications are, the course materials, wage rate, all of that stuff will be there. Anticipated TA, other support, and then wherever feasible, they need to post these at least 8 weeks in advance, and that they have to leave them up for 2 weeks. You need to provide a resume or a CV, including all of your previous appointments within the bargaining unit, and then any other information. Okay, so C is where we get into a bit of the incumbency. So after they've posted everything, the employer has to first offer the appointment to someone that has successfully completed the appointment for the same course at least 3 times over 2 or more separate terms in the previous 4 academic years. That gives you incumbency. You get first crack at it. You can say no, you can take it, it's yours. You can have the right to incumbency in up to 4 appointments per term, and you can claim incumbency for the same course at least 3 times over 2 or more separate terms, and 4 points per academic term, maximum of 9 per academic year. So you can spread them out over the 3 terms, bulk up, the first 2, and then something in like 1 in the spring. That's what we've set as incumbency. Anything, Scott, Jeff, Matt, that you want to add into incumbency?
I guess like a couple of things. There's another line in there that says no employee may exercise incumbency in all sections of a course. So in other words, if there's only 4 sections in a course, you can't claim incumbency on all 4 sections, but you can claim incumbency in 3 sections. And you could probably claim seniority in the 4th. And the reason we have 3 times over 2 terms in the previous 4 academic years, the logic behind that is the university the employer would like to not have to offer incumbency if you've taught 3 sections in 1 course in 1 term and did a bad job. So in other words, the idea is if you teach that course 1 term, if you're good enough to be hired the next term, then you've done a good job, which, basically we all do. And over 4 years, what that does is it allows you to take a year off and not lose your incumbency in that process. And then incumbency is rolling. I just want to point that out too, that this incumbency, the 3 courses, having taught the 1 course 3 times over a minimum of 2 different terms in 4 years, that's a continuous rolling circumstance. But we expect that someone wouldn't take more than 1 year off. If you take more than 1 year off, you're no longer a member of the union in good standing in any case.
Thanks, Scott. Good flag. It does go on. It talks about if 2 people have incumbency and are claiming that for the same course, then it goes by seniority, and seniority is described. Excuse me, sorry. So seniority is the previous equivalent of 0.5 credit appointments in the bargaining unit since your date of hire as a sessional. And so that determines incumbency. It also will determine anything offered after sort of all of those positions with incumbency have been filled. 2 qualified applicants where the qualifications are relatively equal will go by seniority. and that your seniority ceases if you have not worked in the bargaining unit for a period of 24 months, unless it was due to a statutory or some other collective agreement leave. And then we get provided a seniority list for all bargaining unit employees, and then it's accessible to everybody. We get it 3 times a year, and we need to make sure that it is accurate, and we have the ability to challenge that seniority list. F is where we get into the language around grad students, masters and PhD, that they have access to 1 appointment within the bargaining unit during the course of their program. And it's also limited to 20% of the anticipated positions in the bargaining unit. So they cannot bring grad students in to do more than 20% of our work. They also cannot assign them more than 1 appointment per their graduate degree. The employer, they were adamant they needed something here because they needed the ability to assign sessional work to grad students to help them develop. We understood that. We also recognize, the other unit is made up of grad student TAs. We see that need there. So we had to find some language. Somebody described this as we got suspenders and a belt on at the same time. We've got the protection of only 1 appointment per their career, per their program, and then up to 20%. It also talks about how they can't use the wages paid as a sessional to reduce any of the funding for grad students, the academic funding. So that's that piece. Again, I will open up, Scott, if you have thoughts on this that you want to share.
Yeah, just a couple of things. That 20% of Unit 0 positions being reserved for grad students is historical numbers. So what we did is we did research into what the employment breakdown has been, and that number 20% has been consistent for the last at least half a decade, if not longer. So there's no change to the status of employment opportunity because of this. And then the other thing, the other reason for this is because Unit 1 is grad students and is part of our union. We're sensitive to, particularly in the final year of the PhD, where some PhD students lose funding. This is a way for them to sort of bridge the last year of their PhD and also get their toe in the door to get some teaching experience on the CV, so that if they want to become a sessional or apply for tenure track position, etc., they at least have a beginning. One thing we were able to do was exclude postdocs from this category, which is what has been historically occurring. And our argument was postdocs should have teaching experience already and should be able to apply through the normal process. And I will say this clause took a long time. This clause was a big fight, and I think we ended up with good language on it.
Yeah, no, I agree, Scott. Those are good points. And so then in G, there is language around when they don't have to adhere to the posting process. You'll see them there, no qualified applicants have accepted within 2 weeks of the term start date, within 4 weeks or at any point during the term. Somebody resigns from a teaching section or is otherwise unexpectedly unable to fulfill their duties, or due to unanticipated circumstances, they require additional courses. So those are situations where they don't have to use the process above their emergency posting provision, essentially. And then, except in those cases, they have to give you 4 weeks advance notice of the commencement of the appointment, which again is the 16th of the month prior to. So 4 weeks in advance of the 16th, they have to let you know. And then the multiple appointments, that you get your choice of appointment by seniority, and you have 5 working days to accept the appointment from the date it's sent, or 2 in those short notice situations. That is that provision. Let's see, yeah. So I think we'll open up to questions now because that was a big one. Cameron, you're up.
Yeah, first of all, just amazing work on this section. I love everything about it. Before I get into my questions, just I love the tiny little piece where when they're throwing that wild card and just giving a grad student a class, they can't overwrite right of first refusal. I love that piece. So I had a couple of questions. I work at many different universities, and I'm wondering if there's anything about how we're being notified. Like, there's some other universities that I work at that when their postings go up, they send you an email saying you have right of first refusal. This just went live. Or are we just going to be basically prowling the university website, seeing when something pops up?
I mean, we do need to keep track of it, but the language says that they have to, like, after they've advertised it, they have to first offer it to anybody with incumbency. So by my reading, they have to come to you with incumbency and say, do you want this job? And you have the right to say yay or nay.
Okay, so even if there hasn't been a formal application, it still goes to us. And then I was wondering, the wording about seniority seemed a little bit ambiguous. Like, you did say that it goes to the start of your original hire, because I noticed the part where it says previous teaching in the bargaining unit. So that could be read ambiguously as not applying before the bargaining unit existed. But you're certain that this is going to be the first time you've ever taught?
Yeah, so we had lots of conversation about that, and it does talk about the original date of hire as a sessional with the university. It doesn't talk about only as the bargaining unit employee, and we had lots of conversation, and there's actually a section later on that talks about implementation dates, and it's like a little chart. You get all of those teaching appointments back to your first date of hire, and this actually, I appreciate you bringing this forward because it is something that we need you folks. So the employer has said they're going to work on getting a seniority list put together. Their struggle is that the records that they have, there was a change in some software they were using, and so their records are a bit sketchy, and they've got to go back and try and piece all this together, which is going to take some time on their end. So what we suggested to them to try and help is if all of you, because you all have your CVs available and you know what you've done for the University of Waterloo, put together what that looks like, funnel it through the union to HR. HR is going to compare yours with theirs, and when they mesh up, great, no issues. Where they don't, then we have to go and have a conversation and figure out who's right or who's wrong. So it is important that you compile your records and be able to sort of generate some proof, whether it's a pay stub from that period of time or whatever it is. But that is something that they're going to do their work, but they would be open to having us assist with that work and provide them with all of the courses we've taught in order to establish this initial seniority list, which again, yes, date of hire, 100%.
Okay. And then I just have two quick point of clarification. So seniority goes all the way back to your first hire. Does that also apply to right of first refusal, or does incumbency only go back to the unionization?
That is, that's in the chart. I believe we had incumbency to date of certification, but it may be date of hire. Scott, do you recall off the top of your head? We will get to it later. It is in the chart of implementation piece, which I can jump to, but then I'm scrolling and I'm going to make everyone nauseous by watching me scroll through this whole document. Actually, give me a second.
My incumbency is only over 24 months, so then I think it wouldn't. Yeah.
No, incumbency is like over the previous 4 years. And my understanding is that incumbency is backdated 4 years from the next date of application, which will be May 1st.
Okay. And then my final question, sorry for all the questions. Does incumbency apply across teaching modes? Like if you're teaching online and in person, the same course code?
Yes.
Fantastic. Okay.
Yeah, there's nothing in there that distinguishes.
Okay, perfect. Thanks for all the hard work. It looks amazing.
Thanks, Cameron. Covey.
Yeah, I have a couple linked questions about the incumbency and grad student provisions, because it's just worth keeping in mind, right? They're not separate populations. A pretty big portion of this bargaining unit does consist of people who are simultaneously grad students and sessional instructors like myself. So the first is just about whether grad students are eligible to apply through standard procedures. Now, some of the jobs may have a PhD requirement and thus be kind of off limits for people partway through, though others may allow for other terminal degrees. Anyway, that's so the point there is that you negotiated language where the employer can still assign graduate students for our experience and everything else. But do those limits to 20% of the bargaining unit going to count just as cases where the employer has assigned things to graduate students, or also include cases where graduate students applied for sessional jobs?
Yeah, the answer to that is no. Kavi, anybody can apply for any position. And we don't care what their background is if they get the job, they get the job. That 20% gives the employer the right to offer 20% of the positions without going through the application process. But there's nothing stopping any grad student for applying for any position as well.
Okay, that's great to hear. And the only related thing is whether how that interacts with seniority, because in fact, a decent number of sessionals do end up being locally hired, right? Finish your PhD, stay in Waterloo, start working for your department. So do courses you've taught through that assignment process have the potential to count towards seniority?
Yes.
Great, thank you.
Yeah, you are governed by the terms of the agreement once you're in the agreement. It's just that you bypass the posting provision, but once you're in, rate of pay, all the rights under the collective agreement apply to you as if you were a sessional. Benjamin, you are up.
Yeah, thanks. Maybe I think two here. One, if let's say like a course code changes for whatever reason, but the course stays, basically substantially the same, or two courses are sort of melded together, what happens to your incumbency in the old course code? Because I've had that, sort of happen before. Obviously, it was a different system, but course code changes. There's some minor changes to the course, but it's basically the same course.
I don't know. What do you think, Tim?
I think if the positions are materially the same, our argument would be that incumbency should apply. But they can't just go around changing course codes to disqualify us from incumbency. I think that would generate a conversation for sure, and probably grievances if the employer didn't adjust their position reasonably, right? I think.
Yeah.
I'm just going to jump in here and say that that's actually a really good question, because my department recently did that. They switched a course code from Fine 319 and called it a visual culture course, but it's the exact same course.
So what I would think then what we would do is go through the grievance process, start off informally, and say to them straight up, we think this is the same course. We think incumbency applies, and then if they don't agree to it, then we would go through a formal grievance. That's the way I would follow that.
And do you mind if I jump in? My suggestion would be, if like at the department level and the individual employee level, if and when you see these changes, and you come to know in advance, because what you don't want to do is we don't want to be playing catch up and they've already assigned the positions to whomever. We want to be able to identify those things as soon as possible so we can try and rectify it sooner rather than later, and have those conversations up front with the employer if at all possible, I would think.
I think also this goes to the question of knowing what's happening in your department, because those are the kinds of things that get discussed at department meetings, right? But even if you're not at the department meetings, like they'll get posted sometimes in places like Senate minutes or in the calendar, right? Like if you can see that from one year to another, all of the prerequisites for Fine 130 have now just been replaced with VCult 130, and the course description and the class listing is exactly the same. I think it boosts the argument that this is the same class, right? It's just been renumbered.
Back to you, Natalie.
Yes. Okay, I have a number of questions and they may be a bit confusing because it's me trying to sort out what all this language means. But okay, first, how will the university be required to post sessional positions? Because as I understand now, or at least in my department, they're just sort of posted on their website. It's not very clear which courses are available. They just sort of have a blanket statement that they're accepting sessional instructors for various courses. And then you just send in a resume. Um, Whereas at other universities that I've taught at, such as Brock, for example, you have to um, watch the university portal to see if your course comes up, and then you must apply, even if you have seniority. They do not send you anything that says we've listed this position or you have seniority. Would you like it? And if you miss that date, then you don't get it, even if you have seniority. So you have to apply for every single term that you teach. So I'm wondering, like, if there is a kind of portal or central, I don't know, database or website listing where all of the sessional instructing positions will be posted, or if it depends on the hiring policy of each individual department.
So in the language, it talks about a centralized searchable electronic list of bargaining unit positions. So it's
Okay.
It wouldn't be department based; it would be everybody. And then the incumbency piece says that before, like after they post everything, but before they go through any job filling, they have to offer it to anybody with incumbency, and they have the right to say yay or nay before they start looking at people who've applied. That is the way the language. So if it doesn't get implemented this way, we need to know about it so we can follow with the employer to say this is what the language says. You're not doing A, B, and C. Fix it.
Right. Okay.
I think part of the confusion might be between incumbency and seniority, right? Like incumbency is like the automatic right to teach it, whereas the seniority is like in an application process, it's a rank, right?
Yes.
Sorry to interrupt.
No, that's good because this term incumbency is new to me because I've taught for another university and they just use like seniority. There is no such thing as like an incumbency date. So trying to figure out like if you qualify for incumbency, like maybe if I could just throw out a scenario, like if you're a sessional instructor and you've taught one course every fall term for at least 3 years, do you have incumbency or do you have to teach that course again in the winter and then again in the spring and then in the winter again in fall in order to qualify for that? Because some courses are only offered once a year.
Yep. No, the answer to that question is you have 4 years. In that 4 years, you have to teach that course 3 times. And it has to be in a minimum of 2 different terms.
Okay. Okay. That makes sense.
And then that course is yours.
Got it.
And then incumbency continues. And so what that does is it means that you can take a year off in the middle. If you wanted to go out and do a postdoc or something, or postgrad or something like that, you could take a year off and not lose your incumbency. This is why we structured that language that way.
Okay, that helps a lot. I think that's all I have. Thank you.
No worries. Jonathan, you're next.
Thank you. I think it's been made clear, but I just want to confirm. So seniority is going to be tracked in two ways. One, the university says they're going to do it themselves. They're going to go through their Quest records and try to build it up. But we also will be tracking our teaching through CUPE. How is the mechanism in place yet for how we'll where we'll upload our stuff or whatever?
No, it's not going to be through CUPE. It's when you apply, you will have your CV, and your CV will list all of the courses you taught. And then in your application letter, you might want to say my seniority is 17.05 credits equivalent.
Sorry, just to jump in to clarify a little bit. So eventually the university will build a seniority list that will be correct and will document everybody's like where they fall on that list. Right now, they have to build that list for us. And what I'm asking you folks to do is to identify all of the 0.5 credit equivalent courses you have taught at the University of Waterloo since you first were hired, and you can submit that. You know, we'll clarify whether you can submit that directly to HR or you submit it to Scott, and we'll submit all those records onto the employer, and then they're going to compare those records with the list that they compile, and if there's disputes, then we'll sort those out. And then eventually, when we get this list fully done, which I think they have until June 15th at the latest to get sort of compiled, that list is going to be the list going forward. And you will just, every time you teach a course, you're going to get added like an additional essentially point to your seniority list. And that's where things are going to rank out. Does that clarify a little bit better for you?
It does. Thank you. That's excellent. No also, so far I've only taught in one, department. It's the arts department, and I teach at the Stratford School of Interaction Design and Business. Does this make it easier for me to find work in other academic programs, like within the school? And also, Cameron was talking about teaching at different schools, like other universities. Does this tracking make it easier to get work at other universities and in other programs within University of Waterloo?
So in terms of other universities, no. Like the terms and conditions in this collective agreement govern your employment relationship with the University of Waterloo.
University of Waterloo, okay.
And then, but within the University of Waterloo, if you meet sort of the, once the incumbency piece is dealt with, there's going to be, X number of courses left.
Right.
If you have, the qualifications and you have all that other stuff, then your seniority comes into play. And so if you want to get work in another school, another department or whatever, and you're qualified for that work and you have the seniority, you should be able to get that job.
Great. All right. Thanks very much.
Yeah, no worries. Ben.
Hello, thanks. Can you hear me?
Yep.
Okay. My question is maybe nebulous, but bear with me. Do we know how the seniority, or rather incumbency, intersects with the permanent faculty? And this is related to the hiring freeze and general austerity measures, where in my experience, courses that I am the incumbent on were offered to a permanent faculty member because they said they couldn't hire a sessional this term, but next term we'll get you. How would that work?
Yeah, so under management rights, they have the ability to determine which courses are sort of assigned where. And so if they decide to fill positions, like assign courses to permanent faculty, that is within their right to do. And we have no guarantee to force them to make sessional positions. It's where those positions exist within the bargaining unit, then you have incumbency and seniority to those positions. Forcing faculty members to take on sessional work and essentially overloading them is a bit of a faculty bargaining issue, and we don't have really any jurisdiction over that work. But Scott, I don't know if you want to offer any feedback on that as well.
Yeah, they have the right to assign any course to full-time faculty. I will say that the cutbacks are also affecting faculty as much as they're affecting any other labor group at the university. And so I don't see a big move of faculty into sessional positions, but we can wait and see.
Okay, thanks.
Michael, you're next. You're on mute, Michael.
Did that work? Am I still on mute?
You're barely audible, but you are there.
Okay. Then real close. 3 questions, but I think varieties of them have been asked, so I apologize if there's too much overlap. I've been teaching as a sessional since 2016, but I did a bunch of graduate teaching back as far back as 2011. Would that graduate teaching will count towards my seniority?
Were you hired to teach a course for a term?
Yes.
Then arguably that should count. You were hired as a sessional while you were a grad student, but you were hired as a sessional.
I don't know back then, but
I'm really having a hard time hearing you. I've got my volume cranked and I'm just not making out what you're saying.
Maybe I'll just go chat.
Like for TA work, that probably wouldn't apply, but you'd need to figure out what that is, I think. If it was sessional work, then yes, perhaps, depending on
I think
how seamless it was.
Sometimes the standard is like if you're the instructor of record is the term, like if your name is on Quest or the syllabus.
Yeah, he said in, oh, okay. I can read the chat here.
Thanks, Matt.
Second question is, what's the first term this would be applied to if accepted?
The department has formally hired out for spring term. Would that still be in effect? Would we be going blank slate? What would be going on?
So and again, I apologize, I can't hear you. What I think what you're asking is, when do these provisions, so the posting and selection provisions kick in for the fall term, 2026, but they're no later than June 15th because of the advance notice that they have to give for the positions, and then the time that they have to allow you to, accept a position, all that stuff. So by June 15th, this has to be in place for hiring for the fall term. What they said, though, for the spring term, and I don't know where they're at in the hiring for the spring term, but what they've said is that if there are cases where, we identify that we would have incumbency or seniority for a position, that bring those to us and we can talk to HR and we can get those things sorted out to understand either you have the right to that position or why they hired whoever they hired. And what they're saying is in good faith, they want to try and make this language work. They just cannot put together the seniority list and the hiring process for the spring term. It will be there for the fall, but they will work with us to try and make sure that those things are followed as best as possible in the interim until we get to that point. And now my mic is no good. Or is that chat to somebody else?
That's to Michael, that's not to you.
Okay. So, Michael, what I might suggest, I'm going to move on to Benjamin. If you have questions, pop them in the chat, and Matt will read them to us as we go. Benjamin, you're up.
Hi. So 2 questions. I think the first one is quick. Regarding the incumbency requirement, when it says 3 times, that's like 3 half credits over 2 terms. So if I do like 1 section, 1 term, 2 sections, the next term, that works? Or does it have to be like?
No, that works.
Okay. Okay, perfect. And then, so second question, I think it was mentioned that if you don't work at all in 12 months, then I think you cease to be part of the bargaining unit. So what if I'm like
24 months?
24 months? Okay.
Yep.
Okay, that's better. All right, thank you.
No problems.
Dan, you're next.
Can you hear me?
Sort of.
No, okay, let's try this. Can you hear that?
Yes.
Okay, so just the question about being sort of an observation. I teach at St. Jerome's as well, and so we've got a similar union there, right? And I think similar conditions and things. I have right of first refusal on 2 courses. One's offered every fall, one's offered every winter. So just when people are asking about what happens, I mean, in my case, and I guess we can't assume every department works the same or every area works the same. I'll get an email in August saying, or July saying, Dan, you got right of first refusal on these 2 courses, one in the fall and one in the winter. Are you willing to accept them? And they'll send me a contract for the fall and the winter all together in July or August. Now, it's in the university's best interest if they've got sessionals they like and that work for them, and they've got an opening to hire you as quick as possible. So, assuming people are working in good faith, I'm assuming you're going to get as much notice as I get, which is pretty good, because they want to bring you back if you're doing the job for them. So that's it.
No, I appreciate that, and I can't say that the same process at St. Jerome's is going to be implemented at Waterloo, but that would essentially be how we would see it. Like that sort of notice comes out before they start filling positions, and you have that right to say yes or no. Natalie, you are next. Sorry, Dan, you aren't done, right? Your hand's still up, but you are good? Yep, awesome. Okay, Natalie, you're up.
So I just wondered if this spring term will kind of be that rocky in-between period where, the hiring process that is outlined in this document might not necessarily be followed because of how the dates line up. So they won't necessarily list spring term positions this term, but they will do it specifically for the fall. Is that how I understand?
Yeah.
Yeah,
So,
okay.
and no later than June 15th, because again, the posting period is going to start much earlier than maybe it has in the past.
Yes. And I would say just to Dan too, like I've worked for another university and they tend to hire positions like they set up the posting in the summertime and they select basically for positions for the fall term, the winter term, and the spring term for an academic year. So you basically have one period where they hire. They don't necessarily hire term to term to term. So it would be nice to know like if that's how the university is going to conduct it, or if they they have to kind of settle on department budgets and they don't necessarily know if they're going to be able to offer certain courses, in the summer for the entire following year.
Thanks, Natalie. Andrew, you're up.
Yeah, two questions. One about the incumbency, because you mentioned that the university has the right to basically put a full-time faculty into the course maybe that you taught in the prior year. Just wondered if there was any protection for incumbency, say, 3 years down the road, that faculty member moves back to other courses, and that course then becomes available. Is there any protection in the current incumbency clause, or would that be something that you'd be looking into?
Yeah, no, that's a fair point. So I would think like one, we certainly can take that forward and look at that for the future. But if the course is removed and then comes back within that sort of window that you hold, that rolling calendar where you hold incumbency, then you would still retain that incumbency. It's where it would go beyond that, and that's an excellent point that we can look at for maybe future rounds.
Okay, great. And then second question, I'm jumping back a little bit to the pension point. But the language that we have in here is that you shall be entitled to and may be required to participate in the pension plan. Eligibility in such plan shall be determined in accordance with the plan text. I was just wondering, because when I've read the plan, it says that you are eligible if you've earned at least 35% of the YMPE in the prior 2 consecutive calendar years. So just for context, I've just started teaching 2 years ago. I'm just wondering if there's anything in this agreement that prevents them from simply changing the text of this plan as it's posted online and kind of reducing that benefit, or raising that eligibility, said in another term.
I mean, any changes to the plan would require approval through the university process, and there's a committee that deals with those things that has union involvement. We have the right to attend portions of those meetings. We are looking at hammering away at pension in the next round. We know that they are potentially changing the pension plan altogether and moving to the UPP, which we talked about a little bit before. And that's going to require consent from all of the employees in the pension plan currently, whether it's through their union or the non-unionized folks independently. They have to give consent. But so there are changes coming, is what we understand, which is why we got the language that we got, with the hopes that as we, within the next year, we get back to the table, we can look at other things that we can do with the pension plan, assuming they haven't made that change yet. Scott, if you have anything you want to add?
No, I think that, I guess the only thing is, since we raised this pension issue, they started off by saying, actually, you don't have anybody who's a pension eligible, and then they said, well, maybe 5, and then as they've been sort of discovering, we're up to like 25 members, and so this has already been a big move forward for our members. But I think that the move to the university pension plan is going to open it up much more broadly to our membership.
Okay, thanks, Scott. Thanks, Tim.
No worries. Thank you, Matt.
All right, so I was just going to bring up Michael's question. And about the first question that Michael had about teaching as a graduate student, I don't know, like depending on what the circumstances are, we'd probably have to look at that. But even if it's not, so if it's a teaching position that's less than a year, it's considered a sessional position, even if it wasn't called that at the time or anything. So as long as it was within the last, I believe, 24 months, then that would count towards seniority. I don't know if anyone else wants to touch on that. But if that's what Michael did mean, then
seniority is back to the start of time. Incumbency is
yes.
Incumbency is in the last 4 years, and then if you take 24 months off, you lose both of those.
Right. So, but if Michael did not teach, if Michael taught 3 years ago and then did not teach since then, for example, then
no seniority, because if you haven't been employed in the bargaining unit for 24 months, then you lose everything. You lose your seniority, you lose your incumbency, you start at zero. So this is something that people that are thinking of taking a limited term contract should consider, because if you take a 3-year limited term contract and then they bounce you out, you come back to the union and you've lost everything.
Yeah. And so the second question was for something like the university colleges, so St. Jerome's, for example, they offer a lot of the same courses as main campus, and would those count towards seniority and incumbency?
No, so like this relationship is the University of Waterloo and CUPE 5524. St. Jerome's, the other colleges, they have their own agreements with their own employees and their own where they're unionized with their own unions. So we deal solely with the University of Waterloo.
With the caveat that if they're cross-listed as University of Waterloo courses, then yes.
But if they're cross-listed, but then you're an employee, you'd have to be an employee of UW, right? Not an employee of St. Jerome's?
No, that seniority is just if you've taught a course.
I guess I just mean like you have a cross-listed course that could be taught. It's got 2 different numbers, one for St. Jerome's, one for UW. It could be taught by a St. Jerome's person, or it could be taught by a UW person, right? So is that instructor covered through our union either way, or only if they're an employee on the UW side?
I think they would be covered for the UW portion, but they would be covered like by CUPE, but the St. Jerome's portion would be covered by the St. Jerome's union.
But I mean, it's just the one employee has their employment, like the course is cross-listed, but there's not different halves of it or something, right?
No, there's not different halves of it. Tim, how would you solve that problem?
Although I guess certain students might be enrolled in different.
Yeah, and Tim, if you could solve that problem, and then I think we should move forward because we're running out of time.
Yeah, I mean, if it's posted through the University of Waterloo, then anybody in 5524 that has incumbency should get that course. If it's not posted through the University of Waterloo and it is posted through St. Jerome's, we don't have right to that work. So depend where it's posted and how it's posted.
And if I might just quickly, in response to Jessica in the chat, so no matter if you're a graduate student or not, if you're teaching as a sessional instructor, you're within the unions, and so that would count towards seniority. I think that's what the question's asking. So it doesn't matter if you're a graduate student or not. Okay, Jessica.
Hi, can you hear me?
Yep.
Excellent. So I think what Michael is asking is because, for example, he and I were graduate students in our department and then graduated and now are working there as sessionals. So I think he's asking, are the courses that we taught years ago as part of our, say, master's or PhD type of thing, would that count towards our seniority?
Yes.
Okay.
As long as they weren't more than 24 months ago.
No, seniority goes to the point of the very first time you were hired, as long as you didn't take 24 months off.
Right. Okay.
I think that's what Jeff was suggesting.
So the idea is kind of that seniority is your total coursework, like how much you worked for the employer over that whole life of being an employee, unless you took the 24 months off, then it resets. Right?
Okay, so in that case, if you did not take 24 months off, you would have to look all the way back to when you were a student, basically, to figure out your date of first start?
Yes.
Yep.
Okay. And then I actually have a question my own, if that's okay.
Yep, sure.
So that question would be, if you do end up having incumbency in a course or say multiple courses, do you still have to apply each term for that role, or can you expect to basically just be somebody reach out to you because you have right of first refusal?
So the way I understand the language, they are supposed to notify people with incumbency after they posted them that you have the right of first refusal before they do anything else. So you're supposed to get notified. You need to let us know if that's not happening so we can address that issue.
Okay, so I guess my question is, would you recommend that we wait to hear from them? I feel like there's going to be a bit of anxiety of, should we just apply anyway to make sure we get something?
I would apply anyway. Yeah. Tim, what do you say?
Yeah, I think like to deal with some of those nerves as we implement things, for sure, I would, if it makes you feel more comfortable, apply. But I mean, I might just send an email to, whoever does the hiring in your department, say, hey, look, I've, under my collective agreement, I have incumbency to this course. I should have that right of first refusal, and force the issue that way, as opposed to, because what I don't necessarily want to see is us waiving our rights to this notice, right? Like, I don't want us to set a practice in place where we're applying for jobs and sort of giving up this right that they are supposed to be letting us know that we have that right of first refusal. But certainly, as we implement this deal and things get sorted out, I do think if it's going to make you sleep at night, you should follow up with your department and say, I have incumbency in this course and I want to teach it. And then, we can deal with those issues. But ideally, they should be notifying you. And again, they have to post everything at least 4 weeks in advance. And then they have to notify people. So if you're not hearing anything by sort of like the third week before a term starts, you should be following up and saying, you're supposed to let me know about this, and then we can figure it out and let the union know so we can go to HR. Because these are going to be processes that have to be implemented, and they will get streamlined and everything will make sense. But 100% right now, there's likely going to be mistakes and bumps in the road. And so the sooner you can communicate with us, the sooner we can try and address those issues. So we're not dealing with, a wave of grievances that, may not accomplish much because they've already sort of set the wheels in motion, and then we're like into the term and you've lost that. So yes, good timely communication is key.
Okay, thank you so much. I appreciate it.
Yeah, no worries. Cameron.
Hi, I was just wondering, like you mentioned that the university is going to make like best efforts in the spring term to try and do what they can before this goes like fully live. I have a pretty good relationship with like the faculty member that does the hiring in my department. Do you think I should, like, would it be appropriate for me to just reach out and say, hey, quick heads up, if you're looking at the spring term, here's the ones that under the new agreement I would have right of first refusal on, just so they're aware of it?
Yeah, I don't think that hurts, but I wouldn't do that today. I would wait until we make sure that this deal ratifies, and then for sure you can bring that sort of information forward and see how that goes. And then, yeah, go back to Scott. If you get pushback on it, go back to Scott so we can go to HR, because they did say they were going to try and work with us to resolve those issues. Okay. I'm going to move on then, just in the essence of time. So duration, this goes until April 30th of next year. It does seem like a short deal, but it covers off the last 3 years. The key here, though, is also that we have the same expiry date as the TA unit in their tentative agreement. We also have the same expiry date as the other CUPE union on campus that represents the trades, maintenance, food service folks. That is a whole bunch of employees on the University of Waterloo campus that all have the same expiry date, and with some coordination could leverage that into some very positive bargaining outcomes. Dan, are you okay to hold your thought just so I can get through the wage piece? Because I think that's going to generate a lot of questions, and we are pushing up against time. So if we're okay, I'm just going to go through the wages and then I'll open it up for questions. Okay, so the minimum wage rate, you'll see May 1 is $89.10, and then May 1, 2024, you got a 3% increase on that. May 1, 2025 is another 3%, and then May 1, 2026 is 2.5%. And then, equivalent to the 0.5 rate. They're compounded. You also receive additional 4% of statutory vacation or 6% as per the ESA. So after 5 years of employment, you go up to 6% of vacation pay. That is on top of the rates there in that grid. And then the rate you're paid includes all of the statutory holiday pay, onboarding activities, and then work done during the appointment period, as per Article 4, employee duties. The employer may require or permit certain courses to be jointly taught. You just get the proportion of the rate of pay for, if you teach half a course, you get half the pay. They are going to move to a biweekly pay system by no later than May 1, 2027. They needed some time to implement that. They're going to try and get that done as soon as possible, but they at least are going to have it implemented by May 1 of next year. We have language here about, the payment for graduate students for completing the appointment. These are folks that have posted in independently. They're not included in the calculation of any of the graduate student funding. If you are accepting an appointment for a new course, you get $2,400 per half credit course or equivalent based on the course weight on your first regularly scheduled pay date. The employer can still hire people externally to design courses, but if they're hiring you to design a new course, you get the $2,400. If you accept a appointment and there's significant revision, you get $1,200. Same language there. If you earned pay for an appointment, you will receive that same rate of pay. So you will not go down. So if you worked an appointment that was paid at $10,000, if you work that same appointment the next term, your rate does not decrease. They will issue you a record of employment upon your request in compliance with Service Canada requirements. We've also got language here that they are going to, and there's no monetary value. This is not saying this how many hours you work, but just for employment insurance reasons only, they're going to list your work hours as 235 per appointment. This will allow you to submit for EI and have an easier time getting it because it gives you, because there is no real defined hours of work, it gives you the ability to make claim that you have worked X amount of hours to meet the threshold for EI eligibility. So that's the amount of hours we've laid it on there. This is the hourly work provision in 1803. It's $80 an hour. That's work that's assigned and approved by the employer. That's above and beyond your normal work covered by the duties of the appointment. And that you will get paid no less than 2 hours for that time. Course cancellations.
And do you want to also just quickly mention the holiday thing in the middle of 1803?
You may as well go ahead, Matt. You've got it there.
Okay, sure. I don't know, maybe Scott should, but so as you all probably know, for example, if you normally teach on a Monday and Monday is some sort of holiday, they're going to reschedule that class day onto another day. And we were able to get this language in where if you did have class scheduled on a Monday and it's scheduled to some other day, that you should be paid, according to this provision, the hourly rate for that time. And so that makes up for the idea that we don't really get the public holiday because they just shifted onto another day. I think that's all.
Yeah, thanks, Matt. Okay. Scott, do you have anything you want to add there? You good?
No, just 100%.
Okay. So then course cancellations. So you'll see here that when the course is canceled, after the bargaining employee has accepted it, but before it commences, you receive payment of 1 week. Then where it's canceled after it's commenced, but before the term commences, so essentially that period between the 16th of the month prior and the first day of courses, you get a reduced payment of what you would have received had the course not been canceled, prorated for what you actually did, plus 3 weeks. And then if it's canceled after the term has commenced, you get what you would have been paid for that term prorated to what you did, plus 6 weeks. For benefits, okay, I can stop there. Dan, I know you had a question, and I said after wages we would stop. So, Dan, if you want to ask your question now, go nuts. If you're okay, I'll carry on.
Carry on.
Okay. Cameron, your hand's up.
Yeah, I'm just wanted a bit of clarification about the whole designing new courses or revisions, because like I just design all of my courses, and if I'm revising it, it's because I've been teaching it for so long that I want to update it. So I'm not really sure what that looks like, because like if I take on a new course that I haven't taught in the department, they're not gonna basically give me the old class. Like I'm designing a new one, but it's just because I haven't taught it before, so I don't know how that works.
Yeah, Scott, maybe you can speak to that a little bit.
What that sounds like to me, Cameron, it sounds like G, a significant revision or creation of course material. It says as determined and pre-authorized by the university. So in other words, before you would make this claim, and probably before you would do that work, you would want to go to whoever hired you or your department head and have the conversation and say, I have to pull this entire course together. Sure, the structure might be there, but I have to put together, like, I don't know what you teach, but if it was history theory and you were teaching an entirely new topic and you had to pull together all of the reading lists, etc., then I think you could make a legitimate claim under G. Under F is if it's a brand new course that no one's ever taught before, or that's just been invented and they need everything put together, that's F. Does that make it clear, Cameron? Okay. Pooja?
If I could just quickly add on something to that, which
Sure.
is that I think the another part of that is I think the intention was in the job posting itself that this kind of expectation would be made clear, whether significant revision is required or not. And so that might get a bit messy if they're posting and it doesn't say you need to revise a course, but it ends up you have to. So, but the intention was for that to be laid out right from the application process.
All right, Pooja.
Hi, I was just wondering about the same provision. Is that retroactive? I did the piece where there was a new course which was created for winter 2026, and the only thing that was created for it was the 2-3 line description on Quest. So I did design the course with that expectation, but I'm wondering whether that when does that apply? Does that apply to courses which are already running?
No, it would. Okay. Yeah, everything's subject to date of ratification except where explicitly stated otherwise. So, like your wages, there's some retro there and some of like the seniority pieces and whatnot, but the rest of it kicks in once we ratify. So, on a go forward basis.
Okay. Thank you.
Yeah, no worries. Natalie?
Yeah, I just wanted to chime in because I might be able to provide like some examples of how the course design differs from, say, making some minor changes to assignments or adjusting a syllabus or a course schedule, because I've had to do a couple of course designs. One was very extensive and took over a year. Another one was, here we have this course, no one's taught it before. Here is a 2-word blurb. It's your job to put together a new course. In the other instance, it actually involved the writing and publication of an online course that required me to work with the Center for Extended Learning. So I think in that case, it would be, what is it, like that's like a fully designed course, which I guess would be like 2,400 on top of the sessional rate to teach it, as I understand. But in that case, they hired me as a kind of second sessional. So they gave me like a second sessional rate to design it and then teach it, if that makes sense. But I think that's a kind of a specialized case because it was specifically for online. So I don't know how that would be handled, but.
Yeah, and I think that the last sentence in F and in G, which states that the university can hire someone to create a standalone course, that would, to me, that would be the condition that you're describing, where you were hired to create a course and you were paid a certain amount, whether it was a sessional amount or not, right?
Exactly. Yeah. Yeah. Whereas the other example where it's like we have this course, it's listed in our course calendar, it's new and no one's taught it. It's your job to make it or develop it then. That would fall under G, right?
Or F. I
Or
think
F,
that
yeah.
I think if it was brand new, it would be F.
Okay.
If it's a revision, it would be G.
Okay. And then this just popped into my head. So say you apply for a sessional position for a course that you've never taught before. Does the department have to give you an example syllabus? Is that written in it or?
No.
No, they don't have to. Okay.
Well, we don't have any language on that.
Okay. I just wondered.
Okay, Sarah, quickly, and then I'll go to Cameron.
Yeah, super quick on that. I wanted to add that, yeah, I think when it's a brand new course, it sounds like based on the language that if you're being asked to completely design it in order to then teach it, that's where the supplement would come in, versus if you're being hired to design the course, but you might not actually be teaching it. Like in my department, we had hired a Russian sessional to design online Russian courses. And it's similar where it's a full sessional rate. And it was considered equivalent, like the way we had to work with CTE on it as well, the Center for Extended Learning, the online folks. And initially they didn't even know what to do because like their course design process is based on like faculty getting a one-term course, like a one course release for half credit equivalent. So yeah, it's kind of a lot more work, but yeah.
That's exactly what happened to me. Yeah.
Okay, great. Let's go on to Cameron.
I just have a question about the benefits section that we just read over. I'm going through the EFAP website and I just can't find any information about like the limits of the counseling. Like, do we only have so many appointments that we can make, and you might not have the information but like, do we have like a yearly limit of how much counseling we can get?
I don't know for sure, but I think the answer is no limit. They don't even ask for your name if you don't want to give it to them.
But I will note, like, prior to this agreement, there was, like, they were not, basically they said sessional employees don't have access to this, but they would give you access on a one-off. We just want to make sure that it was enshrined here that you had access to that service that everyone else has access to within those limits. It's really like, I mean, there's probably some cost to the employer, but to add you folks on is probably, next to nothing. I think the more important piece, because we haven't fully reviewed benefits yet, is that second article there, where if you've taught at least one credit in the last 24 months, that in your next term employed in the bargaining unit, you're going to receive $200 per term in lieu of benefits, unless you have, unless you're part of the benefit plan elsewhere. But that's a big one, and there was a lot a lot of conversation with the employer about benefits and what that looks like. They wanted this one. Initially, there was no appetite at all. They wanted it in LAU. We pushed. We got this language in the collective agreement, which gives us something to build off of, and ideally down the road, we work towards whether it's some sort of benefit plan, or like a healthcare spending account, or increasing this percent in lieu, or this payment in lieu, whatever that looks like. But we are like this is where we build off of for benefits. Any questions on benefits while we're stopped? Yes, Kate.
Yeah, just the specifics of how that works. Is it, as long as I've taught once in the 2 years previous, if I'm teaching for a term I get 200, or is it okay? So it's terms that I'm teaching. Okay, yes. Perfect.
Okay. And then training opportunities. So you get to be informed of resources for training, and they will not unreasonably deny you opportunities to participate. And then the mandatory training piece is the one where, when you are first hired, you receive the hourly rate of $80 an hour, up to a maximum of 5 hours for completing any of the mandatory training. And that it will be paid upon successful completion, and it will be included in the first pay of the term of your employment or your appointment. Where they direct you to complete additional training, after you've been hired and been working a while, they still have to pay you the applicable hourly rate for reasonable time spent completing the training. And then where you anticipate that it's going to exceed 2 hours, you have to seek approval before starting the training, and then you will be paid upon successful completion. So this is where, like, you get hired. Initially, you have to do WMIS. That's part of your 5 hours here. 2 years from now, you've got to redo your WMIS. You get time paid under this because it is a requirement to do. Does that make sense to everybody? Everyone clear on that, how mandatory training works? Okay. For allowances, you've got your travel expenses. If they require you to travel for any work-related purposes, you get reimbursed for the reasonable costs in accordance with Policy 31. And that if they make changes to that policy, they have to consult with us around the effects. Your change of work location, if they change your primary work location after you've accepted the appointment, then you get paid for the travel from the original work location to the new one. Again, in accordance with that policy. And if you're required to attend an alternate work location on a temporary basis, you still get reimbursed for that time, or for the travel. Leaves. So you've got all the statutory leaves under the ESA, and unpaid unless they're required. You will accrue applicable seniority while on these leaves. Your sick leave is 2 working days per term. And then you have to provide notice as soon as reasonably possible when you're not going to be around. And you can request unpaid sick time as well. Bereavement leave, you're eligible for 2 working days of bereavement leave. You can request unpaid bereavement leave. Jury witness leave, you will continue to get paid. You have to just submit to the employer notice that what you were doing, and it will be, your pay will be offset by whatever you receive for jury pay. And then we get into the letter of understanding around implementation. So again, your wage rates go back to May 1, 2023. Seniority, we've talked about, date of hire. Incumbency is date of hire, but again, that rolling calendar. Biweekly pay, April 30th of 27, if not sooner. seniority list and incumbency, again, completed by June 15th of this year. Posting and selection not later than June 15th, in place for the fall term. The retro pay is going to come 60 days after ratification for current employees. And then by the end of this month, by the end of February, we're not in February yet, thankfully, notice goes out to past employees, and there will be payment to them no later than the spring term. We'll get into what that looks like. Dues, they are going to start collecting and remitting dues to the union within 60 days of ratification, but they will start, like, those deductions are going to be calculated as of date of ratification. So you may not see dues deduction immediately, and so you may see a larger chunk of dues deducted when they get this all set up, but it is just to make up for the time they should be deducting dues from date of ratification. And then the idea of the 2 weeks, the 16 days prior to the start of the term. So that's going to start August 15th, and the payment of training starts in the spring term of this year. Again, they're going to make reasonable efforts to implement all these things. Factors out of their control won't constitute a breach. And then, so this is the retroactive pay. So, if you've held a bargaining unit position within 24 months prior to ratification, so you'll receive, all bargaining unit employees will receive a lump sum payment of $300 for every half credit completed between May 1, 2023 and April 30th, 2024. So that handles sort of year one of the agreement. And then all bargaining unit employees that are paid above the base rate of $89.10, they receive a lump sum payment of $225 for every half credit appointment completed between May 1 of 24 and April 30th of 26. And then all bargaining employees that are paid the $89.10 get full retroactive wages for all appointments completed after May 1, 2024. And that's where the 3%, the 3%, the 2.5% come in. So any of those appointments you worked, if you were paid $89.10, you will get the difference to make up. So you will be paid the increased wage. The employer is also going to try and reach out to all former employees that qualify, and let them know that they qualify for this retro pay. They have to then respond and say, okay, here's where to send the money to, or, you know, this is my banking information. As long as they respond within 120 days, they'll get paid that money. If they fail to meet that 120-day window, then that money is forfeited. And that is everything. I'm going to, open it up to questions. Cameron, your hand is up first.
Yeah, sorry, I have so many questions. I just have one quick one at the end here. So I'm wondering about, like, the boundary case, or like when incumbency expires, because I was just looking at my CV and I have a course that I taught winter of 2023. So would that still qualify? Like, because I've taught it 3 times in total since then, but that's the first one. So would that still qualify for winter of 2027? Like, does it go from the end of the term? Does it go from the start? Or is it, like, based on when the hiring's taking place, or like when the teaching will take place? So, like, when does it actually expire?
I almost need to draw a chart, or almost need to draw a picture. If you've taught it 3 times since, then you've got incumbency, right?
Yeah. So I've taught it 3 times in total, and the first one was winter 2023.
Okay, so I'm just going to write this down. Winter 2023. And yeah, so have you taught it 3 times in the last 4 years? Yes. You have incumbency.
Yeah, so my question is just, when would that expire?
Well, if you stop teaching it, then like for 24 months, then you would, if you stop teaching that course if you stop teaching period for 24 months and you lose everything, you can, if you've taught that course 3 times over 2 terms, that could be 4 years ago. And you would still have incumbency, right?
Yeah, like if it was winter 2023 and they don't offer it again until like because say spring of 2027. Would it still qualify? Because technically I was teaching it until April and they're hiring in April, or
yeah, and also we have like now our appointments are an extra 2 weeks. Our appointments now are going to be starting 2 weeks in advance of the term. So that provides you with that 2-week overlap, right? So you're always safe with an overlap.
Okay. So then technically when they're doing the hiring or even the start of the position, it would be in winter of 2027 for the spring. So at that moment when they hire, I still have my incumbency.
Yeah, exactly. Yep.
Okay,
and you'd be working, like, technically if you're in a winter term, you would be starting working December 15th or December 16th. Based on that's when the appointment would start. So now we've shifted the appointment dates from the start of the term to 2 weeks in advance of the start of the term.
Okay, so basically the next term 4 years later is the latest that you could carry it forward. Okay.
Yeah. Although I would like to see this, I would like to draw a picture just to make sure that I'm 100% correct, but I think I am. Jessica.
Hi, I have a question about the sick or medical leave. Specifically, quite honestly, because I'm thinking of a term where I had to take, I think, 3 days off because I got the flu. And so I noticed that it says 2 days of what I'm going to say is teaching or assigned duties. And so what would you do if you had to miss, say, a 3rd day for a legitimate reason?
Yeah, sorry, go ahead, Scott.
Or do you want to go ahead, Tim?
No, you go ahead.
I would talk to the director of your program and say that you're still sick.
Okay. Yeah, that's what I did. So, but thank you.
Yeah,
we fought hard for this, and we had, like, I'm not happy with this number. I will confess that, but this is what we got. Andrew?
Yeah, just a question for, let's say you taught in the School of Accounting and Finance and your pay rate was 10 grand, so a little bit above that minimum in 2024 and 2025. Does that mean that there is basically no change in your prior pay rate? You just get this lump sum payment and it will only increase once that sort of minimum of 9,400 or so kind of bumps up against the 10 grand?
In this current contract, yes. We'll be rebargaining in 2027. Okay. But this was one of the softs that we did, is that we sort of biased our raises towards the lowest paid employees. And we figured the ones that were making 10, 12, or 14, or even more, there's about 20% of our membership that are just completely off the grid, that they've bargained their own raises in effect. Right.
Okay, great. Thanks.
Dan?
Again, good job on this, folks. It's a great first contract. And again, I realize it's a work in progress too. So this is a good starting point. So thank you for your work. Question though about remuneration and maybe going forward. Okay. Do we even look at prorating based on class size? Because I'm looking at last term, I had an in-person class of 30 and I had an online class of 1,700 and I got paid the same for each course.
So I get your point. Right now, we don't have any language on that.
No. I said, but let's face it, right now we're saving jobs and getting protections put in place, and this is great, right? It's a great start. But I'm just saying down the road, is that something we look at possibly? I mean, if we're talking about equity too, right? It's
So let's just say this, Dan, like, We're not top down. We are the union is the union, and so any issue, like we basically tried our best to bargain our members' issues, and any issue that the membership wants is something that we will bargain. And so we're going to be going right back into bargaining in the future. If you just keep and any points in this contract that we think we need improvements on, and it will let us know what to bargain for, and we're also going to be having a call for new bargaining members going forward. So, the kind of work that gets accomplished is largely done by the people that do the work, and also by the contributions of just the information and feedback that we get from our membership about what their priorities are. And so that one, I know other universities have language on that. That for us as a bargaining committee was never raised as an issue, and never even raised to the level of my consciousness, I'll confess.
No, and that's not a problem. Like I said, right now, I mean, your priority was right. Let's get a contract in place. Let's get something we can work with. Let's get a great starting point, and let's do things to protect people's jobs and people's careers. So, I mean, again, great start. And yeah, we just continue building.
100%.
Yeah, thanks, Dan. And just to echo Scott's earlier point, we'll likely be holding elections for the bargaining committee within the next 4 to 8 weeks, and we welcome people to come out and run for those positions, and then we will start planning and setting those priorities through the various ways, surveys and conversations and all of that. So yeah, I appreciate your comments, Dan, about how it's a good first start, because it is, and I appreciate a lot of the positive feedback I've seen and heard today. It's good to see. Thank you. I appreciate that. Covey, you're up.
Yeah, no, this is exciting to hear about. Just more concrete question without pulling the calculator out. Do you have the cumulative minimum wage increase across those 3 years? What percentage is that?
I could figure it out right now if you give me 1 minute. I'm just going to spend a minute on my calculator.
I was told you shouldn't count your money when you're sitting at the table.
Right, and we haven't ratified, so right now it's 0.
Exactly.
I can just, while Scott's doing that calculation, I can just sort of speak, my role as the researcher for the post-secondary sector in Ontario. I can kind of speak to this as a sort of sector-wide. Your wage rates are well in line with, what we see at your comparator universities. Even at some of the bigger ones, I would say that you're sort of nearing the top end. So your wage rates are good. The increases of 3, and 2.5 are also well in line with what other CUPE sessional agreements have been getting. We're all aware that we are in a major crisis right now in post-secondary. You all know that the funding we get from the provincial government is absolutely horrific and abysmal and shameful. And then we have this international student issue to deal with as well that has kind of collapsed a bit of the house of cards that was propping up universities' budgets. So I think for us, seeing anything with a 3 is like a huge win. Very, very happy that we were able to secure those increases going forward. So just kind of wanted to add in my perspective, sort of where you lie when we look at other agreements in the province as well.
Awesome. Thanks,
okay,
Katie.
Don't quote me, but I think compounded 3, and 2.5 comes to 9.25. I could be wrong because I just did this on my calculator. And but then I want to say on top of that, where else have we got money? We've got money through we've got another $200 per term, which is approximately 2% in terms of substituting for healthcare. We have pay for now taking training, which is another for first time doing WMIS is going to be another $400 if you do 80 times 5 hours. And we also have we have the T2200, which could be substantial in terms of reducing your tax payments. One other place we got money. We were trying to get money in every single pocket we could possibly find. And so the 3.3 and 2.5, while it's okay among the industry, we're not doing bad. Other universities are getting numbers lower than this. By the time you roll in everything that we've sort of got, we've done quite well for ourselves.
Yep. No, for sure. For sure. Okay, I'm going to stop sharing. And then, yeah, I mean, I think we've got through everything. I'm happy to close it out. I actually have another meeting I have to get to. But I'm happy to leave this open if people need to stay on and ask questions to Scott, Matt, and Jeff. But again, I just want to repeat that, like, there was a ton of work done by your bargaining committee on this deal, and the support staff, Joel and Katie, could not have done it without all of them, and they do deserve a massive amount of kudos for getting this thing across the line. I do, again, we all recommend unanimously that you accept this deal. I hope that you, as you vote, will vote in favor of it. If you do have questions that come up after this, reach out through the union email. It will be monitored over the weekend during the voting period, and they can get forwarded on to myself or Scott or the rest of the bargaining committee to figure out answers to, just in case you do need some clarification before you vote. And you should be getting a ballot, if you don't have it already, from Simply Voting. And again, please vote yes. Scott, you got anything you want to say?
Yeah, the email from Simply Voting, I got it in my inbox at 10:01 this morning, and it was supposed to go out at 10. So everyone, please check. The headline just says CUPE Local 5524, and then the subject matter is CUPE Local 5524 Unit 0 Agreement, and that has the link to vote for the contract in it. So if everyone would do me a favor and vote immediately, we are going to have our contract action team contacting our members over the weekend to encourage the vote. But if we can get everyone who's here now just to take that 1-minute task. And then Sarah, who is the lead of the contract action team, has got something to say. Sarah?
Yeah, thanks so much, Scott. Yeah, I was just going to say, once folks have all gone and voted right now, if anyone is willing to spend a little bit of time over the next, whether in your department or outside of your department, we'd love to join us for that get out the vote kind of process. We have scripts and templates. It's just like reaching out to members, like giving them a quick call, making sure they know that the vote's happening. We can answer any basic questions they have about the CA, but anything more complex, we pass up the chain. And then we just double check, contact them, ask if or when they're going to vote, if they've already voted, and then we just check them off the list. So yeah, if anyone is willing to help with that, if you stick around in this meeting for a couple minutes after, I can get your info, or I'll put my email in the chat, and you can reach out to me, and we'd love to have you. It's only a couple days commitment, but it would be really, really great. Thank you so much.
Yeah, so Sarah, you broke up a little bit there, so I'm just going to repeat what you were asking for. Sarah, runs the contract action team, which we call CATS, which is basically outreach to our membership. This is how we sort of know what our membership's priorities are. And Sarah is pulling together a team of people to just do some outreach to our members. And if anyone wants to spend a short, it could be as short as an hour over the weekend, Sarah will offer you a list of people to just reach out to about voting for the contract that didn't make it to this meeting. And any help there would be really appreciated. Sarah will put her email address in the Q&A, or in the chat, sorry. And why don't I say that this is the end of the formal meeting, and we'll just hang around and have a informal chat about this until if anyone has any further questions or things that they just want to talk about in general. I want to thank Tim and the team, especially very much for the work that they've done as well on this. I'm pretty happy with this contract myself.
Thanks, folks. It's a good, solid agreement. as far as I'm concerned, it's a mature agreement in many respects. I've seen inferior contracts that have been in existence for an extended period of time. So good job and good luck with the vote, and take care. Bye.
Thanks, Joel.
Thanks, everyone. Good luck.
Take care, Katie.
Thanks, Katie.
Thanks, everybody. Have a great weekend.
Bye, Jeff.
See you, folks. I do unfortunately have to run, but yeah, Scott, if there's anything that comes up you can't answer, just send me a text.
Will do, Tim. Thanks a lot.
Thank you all. Yeah.
Jeff, who just left, I just want everyone to know that Jeff has probably been the longest standing bargaining member of the committee. His partner sent us Christmas cookies when we were bargaining over Christmas. And I will say that the first Christmas that we got the Christmas cookies, it was joyful. And the second Christmas that we got Christmas cookies, it was a bittersweet moment, even though the cookies weren't bitter.
All right. Thanks, folks.
We'll talk man.
All right, Tim. Hey, Andrew, you have a question?
Yeah, first, just wanted to echo what everybody else said. Thank you for all the hard work that you've done. I'm sure it was a ton of work to get it to this point. And then just sort of, I guess, an open-ended question. Wondering what you wished we could have gotten in this round that you're looking to get in the next round.
So, okay, I'll give you my list. One thing that we need to work on is benefits. So what did we get? We got EFAP and we got $200 a term. That's not as good as other universities. Part of the problem is that the University of Waterloo does not have the capacity to set up a benefits plan at this moment. And what they actually initially offered was that they would just give a bunch of money to CUPE and have CUPE run the benefit plan, but CUPE doesn't work like that. And so in the end, because we wanted to get a deal and we didn't want to sort of delay it over this process of figuring out how to get a health insurance plan in place, as we agreed with payment in lieu for $200, which is not enough. But one of our tasks, I think, is we're going to set up a health insurance committee over the next few months, and we're going to investigate other health insurance plans that, for example, U of T or Toronto Met have in existence, and we'll pull together some proposals and basically deliver them to the employer at the next round of bargaining, which they will be expecting. And then we'll have to negotiate the quality of that health insurance plan, but it'll probably be double the quality of what we're getting now, just in terms of EFAP and $200. I know, like U of T, for example, their base health insurance plan is $550. So that's sort of where I'm thinking about where we're going to be going. One thing we didn't get was matching RSPs. We didn't ask for it. But like it was meant to be a kind of fallback position if the pension issue fell through, and then they accepted the pension issue right from the get-go. So and that would be a substantial raise, and I think we kind of stretch the envelope in terms of money this time. So matching RSPs will be something that we'll do in the future. We didn't get a PERF fund. So what a PERF fund is, like professional expertise or experience fund, where you can get things like reimbursed for conference visits and things like that. We didn't get that. Okay. We didn't ask for it, but that's something that's on the list to get. We didn't get a union fund, which is money that the university would pay for the administration of the union. So in other words, typically like employers will provide something like $100,000 or like a certain number of course credit in lieu that will pay people that work in the union. They were just adamant that they weren't going to give us anything, and we settled on that. And then the pension plan, right now, I mean, it's only accessible to a limited number of our members, but this move to the university pension plan, which is in the works, is an opportunity for us to be able to expand that pension plan much more widely to our members. So those, for me, are my 5 personal issues, but it'll also be interesting to see, as we run through the implementation of this, where the grievances fall, because we'll discover what parts of the contract are working and not working, and we'll also discover
what the issues are for our members that we didn't know before. It'll come clear in this next round. So we're going to be doing a lot of work in the next 16 months, just testing the contract and then making plans for the next round of bargaining.
Right.
If there's anything that you have, Andrew, or anyone else on the call that you think we should be focusing on, this is the information we need to know.
I mean, to your point, the university pension plan, that makes a lot of sense, especially if you are a sessional. I'm not, but if you're a sessional who teaches at multiple universities in order to kind of stitch together a full-time job, then that makes perfect sense that you would want to be in a more general fund that you can kind of use at multiple universities. I guess just my point earlier about the pension was just to make sure that we're keeping an eye on the eligibility, because I think I'm probably one of those, or will be one of those weird 20 or 30 individuals who is eligible only based on that unique wording of earnings over 35% of the YMPE. So I would just suggest to try to make sure that they don't try to decrease that in any way.
No, they kind of can't, because the pension language is very clear, and also the employer doesn't have the right to make changes to the pension plan without consultation with all of them, without consultation of all of the pension members. And so it's not something that they're going to arbitrarily do. And I think that they're going to go with the university pension plan partly because they don't have to run it themselves and they don't have to pay for it, right?
That's a huge administrative burden.
Exactly, and they're interested in dropping that administrative burden. For us, the opportunity, like, we don't have representation as a union on that in the pension plan right now, because they never considered us as being a major player in that. But as what we've discovered when we've been pushing on this is, in fact, we have more members in the pension plan than OPSU, which is the security union on campus, and they have representation. And so this is the argument we've made, is like, they have it, we should get it. And then the employer has sort of said, well, we're in the midst of changing right now. Like, and I think partly it's inconvenient for them, but partly I think that they just don't want to have another voice at the current moment. But once it changes, we will have a better voice.
Makes sense.
Any other questions from any other people? It's 1:30. Can you believe we've been online for 3.5 hours?
I just wanted to say something.
Sure, Nafis.
Yeah. Thank you, Scott, for a wonderful job done. We are very excited about this contract. I've already voted.
Great.
So hopefully, we're going to see a good contract coming out of this.
Yeah, and thank you. No, it's been a real pleasure. I never planned on doing this work, and I'm really happy I did. And I've met a whole bunch of great people, good friends, and also I've grown as a person remarkably. And I would suggest that anyone that has any interest to volunteer to work for the union. And just the thing I have to keep reiterating is, we're non-hierarchical. It's not like I'm the president and I'm telling everyone what to do. Everyone is equal in this union, and the answer to any question generally is yes. If you want to do something, let's do it. And if you want to contribute, let's contribute. And if you have an issue, let's discuss it. And we can work forward together on this.
Yeah, absolutely. Especially even today, the way you guys conducted the whole meeting, it was so informative. I had some questions, but I didn't need to even ask because you were answering those questions ahead of time, or telling us about that ahead of time. A lively discussion. We enjoyed it thoroughly. So amazing work.
Yeah, well, and that's got a lot to do with Tim too. I have to say that I really am grateful for the work that Tim's done for us. And
yes.
we wouldn't be where we are without CUPE's support. We would this just would not have happened. The amount of resources that CUPE has poured into us over the last, even just going through bargaining,
yes.
Hundreds and hundreds of thousands of dollars of salary. like from labor, like from lawyers to researchers to Tim as our CUPE national rep, to just like, it's just a real commitment from them, a union, like a national union of almost 900,000 people to bring us in. And then the other thing that we should all know and we should acknowledge is we're big. Like we're a union between our two unions. I mean, like we're approximately 350 sessionals at any one time, but going back to 24 months, we're about 725.
Yes.
And so that's a big union in and of itself. But if you include the TAs and RAs, that's like 3,500 people. And I'll go to some union meetings and I'll talk to someone and they'll say, oh, like, I'm in a union and I'm like 12 people, and they'll ask me, how big is your union? And I'll tell them, and their eyes will pop out of their heads. So like we're quite powerful, and we just need to like continue to operate on that basis.
Yes, absolutely. Because you feel like, because I've been teaching here for so long. I've been teaching here since 2009. Like you almost feel like invisible. Like you do your work and then you go home. Like, like, at a personal level, get to know people, but professionally, you don't get to. So this feels really encouraging that you have now, at least we have some voice, like, and we can, and we can collectively put forward our demands and have so that's wonderful.
You wouldn't know it based on most universities, but over half of teaching time in the country now is done by sessional and short-term instructors, right? And I'm sure Waterloo is in line with that. But like you said, people are so often invisible. It's really a shame.
Yeah. But I'm very excited. Very excited about this new phase. And I want to thank everyone. Amazing job.
Well, yeah, thank you too, Nafeez.
Thank you, Nafeez. Let your colleagues know to vote if you have folks in your department.
Yes, of course, I will.
Yeah.
All right, take care, guys.
All right, take care.
Bye-bye.
Any questions from the Andrews? We have 2 Andrews up, and everybody else I know personally because they are workers in the union.
No remaining questions for me. Just thanks again. My first time being part of a union, so it was also quite interesting.
Yeah, mine too, to be honest. Shall we call it a day? And if anyone has any questions or knows anyone with any questions, just shoot us an email at minimum to our general email address, and I'll be like monitoring my stuff over the weekend, and someone else will be taking care of monitoring on Monday, because I'm not available on Monday to answer questions, but I am today and tomorrow. All right, shall I say thank you to everyone, and hopefully to see you soon.
Thanks. Take care, everybody.
Thank you, Scott.
Okay, take care, everyone.
See you soon.
Goodbye.
Okay, bye-bye.